Yes.
I pray for listing of the matter tomorrow. Urgency is there. Because executive engineer is required to give a counter signature in the certificate.
We take it up today. The file is.
Yes, 2 p.m.
I'm taking up another matter. Yesterday, I issued notice. That was a case where the site verification certificate was not given, that petitioner could not participate.
Yes.
To take action against these executive engineers. Hence, they had taken it for a ride to tender positions. Anyways, we'll take it up to.
Wait, please, Your Lordship. I pray also for a listing of a matter for motion. There's some urgency in the matter.
Today,
Well, I would know.
I don't have much in the list.
Oblige, Lordship.
May it please your Lordship. Lordship, I beg to mention item number 6, Lordship. Lordship,
Item number?
6, Lordship. Lordship, in this matter, we are going to file affidavit in reply, Lordship, today itself, Lordship. Any date, Lordship.
You are for a respondent.
Petitioner, Lordship. Petitioner, Lordship.
Item 6 needs.
Item 6, I'm inform police.
Is there a stay?
Yes, Lordship.
Yes, there is a statement.
No.
Short date may be given, my lord, they have not filed the reply. They want to file the reply against my affidavit in opposition. Short date may be.
At this time, I don't extend the stay. So no stay, I'll extend it. So you take how much time each?
No, Lordship.
1 year, 2 years? You take? I'm not extending the stay. If you make a mention.
I'm going to
that
file the
is
reply.
taken up, if you say so, then the consideration will be done.
Next week, Lordship. Next week, Lordship.
I don't extend stay. You want how much? Yeah, 1 year, 2 years also I'll give.
Lordship, today itself, I'm going to file the reply, Lordship.
Fantastic. When the matter reaches, you make a mention then. Next.
I'm praying for listing of a writ petition in the stage of motion tomorrow and
Why?
this writ petition is filed for a tender contract and have been selected for this tender, but on the ground of some technical difficulties, my name was struck out and fresh bidding was held. Please, Your Lordship. Lordship, I beg to mention item number 11, Lordship. Item number 11, Lordship.
11.
Yes, Lordship.
Okay.
Lordship, in this case, during pendency of the writ petition, the management has reinstated all the 34 workers, Your Lordship. Now, sir, only big wages is remaining, Your Lordship.
You want time
Yes, Lordship.
for the petitioner?
Yeah.
I am for the workman, Millard. I am for the work.
You have no objection.
In fact, one compromise talk is going on.
Huh?
In fact, one compromise talk is going on. And management advocate told me and.
It has been submitted at the bar that talks of compromise are going on in the instant proceedings, taking into account the matter will be listed again on 25th of November, 2025.
So, 25th of November. Much.
For admission,
Can it be one day earlier, later, 25th? 25th, I will not be on 26th or 24th.
2nd of December.
Much.
What is this?
May I please, Your Lordship? Your Lordship, this writ petition is pertaining to
Yes, who is paying for the bank?
I'm for the,
Why have you not submitted in time?
we have submitted in time.
No, it has been submitted delayed. That is the reason why it has happened.
No, in fact, your lordship, I have filed one additional affidavit.
Yes.
Wherein the loan is already closed.
Additional affidavit filed on 13/6.
Yes.
No. You are? Respond number 7.
Yes. Loan is closed and no due certificate given. And the money that the money is still in the current account of the petitioner.
No, block. No, as per.
So the money has already been paid by the central government
Yes,
to you.
to them actually. We are
No,
just
no, no. You are keeping it on hold
a hold in terms of the
because
order.
of the pendency of,
Yes,
meaning thereby that the petitioner is entitled is not in doubt. You have also submitted the application in time.
yes,
So therefore, they have already released the amount to you.
yes,
Now, because of the pendency, you have not released.
yes. And in fact, the loan is also closed. The loan is also closed.
But he is entitled to the subsidy.
That is your,
No, that is the fact that he is entitled to the subsidy, because of that, there is not in doubt.
no, yes,
What is the stand of the central government, or so whoever it was, the
Yeah.
granting the loan,
Yeah.
or 1 to 4,
yes,
or granting the benefit,
Yeah.
is on the basis that they submitted the application belated,
Hmm.
isn't it?
yes.
Yeah, the financial institution had submitted the application to the NABARD. The respond number 5 and 6. 7 is
You are
submitted.
paying for NABARD?
And for the NABARD. The only thing your lordship should see that it was not, the amount was not given by to the NABARD up to the cutoff date, that is 31/1/2017.
Then why the amount have already been paid to them?
No, my lord, that was, we have, well, inadvertently, we have stated in our affidavit. We have released it, but then subsequently with the, my lord, high power notification dated so and so, my lord, it was stopped. Now your lordship will see only at.
But
page-
they categorically say on an affidavit filed on 13/6/2025. Paragraph 4 of that affidavit, you should see,
My lord, in our affidavit,
whoever has filed it on 13/6/2025.
that is by
Respond
them,
number
my lord.
7.
My lord, State Bank is not that way very fair to say all that. Because they what we have said regarding the circular, your lordship will.
No, 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 no.
Is-
No, Mr. Datto, kindly see paragraph number 4 of the affidavit file.
I have seen, my lord.
There they categorically say that the amount has been kept on hold by them.
Yes, they have said that. But they are not correct on that, my lord. Your lordship may see that at page. They are saying at page 3, paragraph 4.
Hmm.
Deponent further state that since the term loan sanctioned by respondent bank was subsidy link and the respondent number 5 and 6 had released the first installment of the subsidy amount of rupees so and so, the said amount was credited to the current account of the rate petitioner number so and so so and so. Now, your lordship will find this release in regard to the release of the first installment, it was done inadvertently. Later on, my lord, we corrected it and said there, since within the cutoff date, the amount was not, I claim. So therefore, they are not entitled to it. Now, if your lordship look at the circular, which is the crux of the case at page 191 in their writ petition, my lord. Your lordship will see at page 190 first.
Yes.
The circular number so and so, as your lordship got that. Dated 9 December 2016. It was informed to the chairman.
It has been extended to 31st of January 2017.
Exactly, my lord. And the claim was not made between that time. It was beyond that, March 2017. Therefore, my lord, we are not in a position to pay it because the claim was not made within the cutoff date. That is the short point in this case,
So that I understand.
my lord.
But the short point has become longer because of the fact that the petitioner is not at fault.
My lord, that is the fault of the State Bank of India, my lord.
So therefore, both of you are public institutions. So you need to sort it out amongst yourselves, what is to
My
be
lord,
done, but
they
the
failed to
petitioner is
discharge
not at fault.
Your lordship is very correct. Your lordship, they have failed to discharge their duty.
Yes,
Now-
understood, but then also it is a fight between both of you. Why the petitioner should not be affected? If you have released the amount and the fact that as per that, the circular, he is entitled to.
Uh, Yes, it is, but if it is within the cutoff date.
The fa- the cutoff date question is who is to submit? But the financial
Yes, State
institution,
Bank, State Bank.
the financial institution duly admit that the term loan which have been issued to the petitioner is subsidy linked.
Yes.
So therefore, they say that they have submitted and you have also inadvertently allowed. Then why should the petitioner not get the benefit? Because of the whatever has happened, they were at fault. You have also been complacent enough to be at fault along with them.
Lord, possibly by,
Even there was a
After
joint
the-
inspection. Even there was a joint inspection on the part of the.
you are, again, they are lying, my lord. There was no joint inspection.
was
We
a
are not a
joint
party to
inspection.
it. We have stated in our affidavit.
No, you are not a
Things-
party, but the fact that you have released it, wouldn't it be, cannot there be a presumption that you have done whatever is necessary?
That was the fault committed, maybe
So
inadvertent.
both of you have committed the fault, but the fact that the petitioner is entitled is not in there's nothing, there is no quarrel with that. So therefore, the petitioner should get his benefit of the 16 lakhs, no?
Your lordship, total first installment was 16 lakh. There was a final subsidy amount to be released.
You have got the 16 lakhs.
And that is blocked by the financial institution. That is the first
And the
installment.
remaining amount,
Remaining amount, total amount is, your lordship,
32 lakhs.
32 lakhs around.
How much? Total amount, 32 lakhs.
Yes, your lordship.
When they claim the other, 16 lakhs, all right, it is because of their fault. Now, the other part, when there is no fact in regard to that.
Because.
But the fact remains that it is a subsidy scheme. It is not that the petitioner is at fault. Whatever may be, the petitioner is not at fault.
But so far,
The
Nawali,
filing of them has to be made by the state bank. You have to take it up with the state bank, whatever you do, break their heads or do whatever you like, then you do it. But the fact remains that the petitioner should be given his dues. When he has, on the basis of a particular subsidy scheme, he has done his work. And there is no quarrel, nobody is saying that he is not entitled to. It is only the fact that you have not submitted in time and you have also been complacent enough to allow it
so
or
first,
disregard whatever it is. The fault of the taking it to be a brother institution.
that's a very correct thing, my lord, to suffer first installment. But for the second installment.
Same,
possibly-
yeah. It goes on the same thing. Why not he should be entitled for that also? Taking into account, it is not his fault. It's the state bank. We direct the state, both of you to sort it out amongst themselves and release the amount whichever is due to the petition.
Yes, not a good, it's a good idea.
Heard Mr. S. Sanjati. S or the younger one, you are?
So far, I am allowed for
Yes,
respondent
sir.
number 5 and 6.
S. Sanseti, the learned counsel appearing on behalf of the petitioner. Mr. S. Dotto, the learned senior counsel, appears on behalf of the respondent number 5 and 6. Mr.
Yes.
So and so appears on behalf of the respondent number 7. Anybody from respondent number 1 to 4? That is why yesterday I said, no, not to trust these central government councils. They are not there whenever the matter is. So none has appeared on behalf of the respondent numbers 1 to 4 when the matter has been called for. It is also relevant to take note of that on the earlier occasion also, the matter stood adjourned on account of the non-appearance of the respondent number 1 to 4. So taking into account that the respondent number 1 to 4 have chosen not to appear, this court would take up the instant proceedings for disposal. The case of the petitioner herein is that the respondent number 1 through the respondent number 2 came up with an integrated scheme of agricultural marketing (ISAM), wherein all schemes relating to agriculture marketing and infrastructure were brought under one umbrella for strengthening of the agricultural sector. With the above objective, the ISAM was divided into 5 different schemes. Roman 1, agriculture and marketing, infrastructure, (AMI), merging, merging existing scheme of Gramin Bandharan Yojana (GBY), and development, strengthening of agriculture, marketing, infrastructure, grading and standardization (AMIGS). Roman 2, marketing, research and information network (MRIN). Roman 3, strengthening of AGMARK grading facilities (SAGF). 4, Roman 4, agri business development facility (PDF). And Roman 5, Chaudhry Saran Singh National Institute of Agricultural Marketing (NIAM). The respondent number 3 merged the scheme for development strengthening of agriculture, marketing, infrastructure, grading and standardization (AMIGS) and and Gramin Bhandharan Yojana (GBY) into one agricultural marketing infrastructure (AMI), under which necessary operational guidelines 2014 were also issued. In that regard, the respondent number 5 issued a circular number 71 (D small o capital R 22/2014) under reference number NB.D small o capital R dot GSS /394 AMI-1 2014-15 dated 25/4/2014 intimating to all scheduled commercial banks, all scheduled primary, urban cooperative banks, all RRBs, ADFCS, SCBS, SCARDB'(S) regarding the guidelines. The petitioner, who had a plot of land at measuring 1 biga 2 katha 18 lectures covered by Dag number 743 of PP Patta number 345 of village Hirapara, Moza, Siambari, Dhula district, Dorong, Assam, intended to set up a rural godown at village Hirapara under the Integrated Scheme for Agricultural Marketing (ISAM). And accordingly, the petitioner approached the respondent number 6 for availing a term loan, which was sanctioned by the respondent number 6 by the letter number CB/AMT Roman 1/2016-17/345A dated 11/11/2016, wherein the petitioner's application for term loan amounting to rupees 80 lakhs was duly sanctioned by setting up a rural godown at village Hirapara, Moza, Siambari, Dhula district, Dorong, at a total cost of rupees 1 crore 20 lakhs. The petitioner received the first installment disbursement of the loan on 29/12/2016. To the information of the petitioner, the respondent number 7 applied for release of the advance subsidy to the respondent number 6 with all the required documents on 28/3/2017, that is within 90 days from the date of release of the first installment, as per clause 3.10.1 of the operational guidelines. The petitioner further mentions in the writ petition that the respondent number 7 received the advance subsidy on 25/10/2017 from the respondent number 6 by letter dated 25/10/2017, being an amount of rupees 16,03,800, which is 50% of the entire subsidy amount for and on behalf of the petitioner, which was kept in a separate subsidy reverse fund, being account number 300,742,46297, maintained by the respondent number 7 with its South Guwahati branch, and the said amount till the date of the writ petition remains intact. It is the further case of the petitioner that the petitioner duly intimated the concerned respondent authorities about the completion of the godown on 17/7/2017, and the date of commercial production would be 3/7/2017. The respondent number 7 thereupon applied for release of the final subsidy with the respondent number 6 on 12/1/2018 as per Annexure Roman 13 of the operational guidelines. and requested for a joint inspection of the project. The respondent number 6, along with the respondent number 7 and other officials, conducted a joint inspection of the godown of the petitioner on 27/2/2018, whereby certain observations were given to the respondent number 6 for compliance by the petitioner. And accordingly, the petitioner complied with the said observations immediately. Full stop. The petitioner thereupon came to learn that steps were being taken for recalling of the advance subsidy amount of rupees 16,03,000 by the respondent number 6, 3,800 by the respondent number 6 from the respondent number 7. And this was intimated to the petitioner by the respondent number 7 on 29/10/2018 via an email of the same date. And the reason for recalling of the advance subsidy amount was that the claim for subsidy was submitted by the respondent to the respondent number 6 by the respondent number 7 only on 28/3/2017, which as per the ISAM guidelines was found to be after the cutoff date of 31/1/2017 of submission of the proposal to the respondent number 6. It was therefore observed. Full stop. It is under such circumstances, the petitioner being aggrieved has approached this court by filing the present writ petition, thereby seeking a direction upon the respondent number 5 and 6 not to give any effect to the cutoff date as mentioned in the circular dated 5/12/2016 issued by the respondent numbers 1 to 4 in the case of the petitioner as far as receiving and sanctioning of the advance subsidy claimed by the respondent number 5 and 6 are concerned, as the same was inconsistent with clause 3.10.1 and clause 4.14 of the operational guidelines of ISAM. Further to that, the petitioner also sought for directions to the effect that the operational guidelines of ISAM cannot have overriding effect over the circulars issued by the respondent numbers 1 to 4 authorities in the light of the fact that there is no alteration and amendment in time limit set out in the operational guidelines of the ISAM as far as receiving and sanctioning of all such advanced subsidy claims by NABARD under the Agricultural Marketing Infrastructure AMI subscheme of ISAM is concerned. Pursuant to the filing of the incident writ petition, the respondent numbers 5 and 6 have filed an affidavit in opposition wherein at paragraph number 9, it was mentioned that the petitioner was not eligible beneficiary as per the NABARD circular dated 9/12/2016, inasmuch as the subsidy will be available to those which are received by NABARD regional office on or before 31/1/2017. It was further mentioned that in the instant case, the subsidy claim was forwarded by the SBI by letter dated 28/3/2017, which was received by NABARD Assam Regional Office on 29/3/2017, and the claim so submitted was beyond the cutoff date, and as such, the petitioner's claim for subsidy was evidently not maintainable. It was further mentioned that the NABARD inadvertently had recommended release of advance subsidy of rupees 16,03,800 on 25/10/2017 through e-payment and conveyed the same to the SBI LHO Dispur by letter dated 25/10/2017. However, the High Power Committee during its review meeting held on 25/9/2018 decided to consider the claim ineligible, and the head office via its email dated 17/9/2018 conveyed ineligibility of the claim as it was received on 29/3/2017 after the cutoff date dated 31/1/2017. It was further mentioned that the advance subsidy kept in inverted comma subsidy reserve fund account AC inverted comma closed of the concerned beneficiary by the SBI was recalled by the NABARD by the letter dated 16/10/2018, which was again followed by another letter dated 5/11/2018. It was also mentioned that the advance subsidy so recalled have not yet been was not refunded by the SBI till the time of the writ petition was filed by the petitioner. The respondent number 7 filed an affidavit in opposition. And in the said affidavit in opposition, it was categorically admitted that the term loan was sanctioned by the respondent number 7 in favor of the petitioner on 11/11/2016 for construction of a rural godown in Dhula, Dorong, Assam. And the first installment of the term loan was disbursed on 29/11/12/2016. And in total consonance with clause 3.10.1 of the operational guidelines of ISAM. The claim of release of advance subsidy was submitted applied for by the respondent number 7 with the respondent number 6 on 28/3/2017, which period is well within the lock-in period of 90 days as stipulated in clause 3.10.1 of the operational guidelines of ISAM. And accordingly, the respondent number 6 released the first installment of the advance subsidy for an amount of rupees 16,03,800, which is 50% of the entire subsidy amount under the covering letter dated 25/10/2017. The respondent number It was further mentioned that the respondent number 7 bank, by its letter dated 12/1/2017, had categorically requested the petitioner to claim the subsidy from the respondent number 5 with all required documents at the earliest. It was also mentioned that till date, the said subsidy amount of rupees 16,03,800 received from the respondent number 6 remained parked in a no lien account maintained with the respondent number 7 bank. Further to that, it was also mentioned that the petitioner had completed the construction of the rural godown on 3/7/2017, for which purpose the term loan was sanctioned by the respondent number 7. And in that connection, an intimation letter dated 17/7/2017 was also received by the respondent number 7 along with completion and utilization certificate. And also informed and fixed 3/7/2017 as the date of commencement of commercial production, that is the date from which the commercial production operation of the units shall start. The respondent number 7 further referred to a communication dated 19/12/2017 issued by the respondent number 2, whereby it was instructed as regards the time schedule for completion and submission of the proposal oblique documents for claiming the final subsidy. Full stop. It was further mentioned in the said communication that the joint monitoring inspection is required to be carried out after completion of the project. It was further requested in the said communication to expedite the matter with the concerned regional offices oblique branches oblique nodal branches as per the list enclosed for providing the complete documents in all respects to the regional office of NABARD and DMI before 31/1/2018 to enable them to conduct the joint monitoring inspection for sanction of release of the final subsidy. Full stop. In the said list, so enclosed to the communication dated 19/12/2017, the name of the petitioner featured, isn't it? 237. You are this Sri Ram HUF Salasar Balaji. Is this you? No. Your name is there in the list?
Yes, your lordship, as Kamlesh Kumar Surana, down. 25/10/2017 letter.
Huh?
Yes, your lordship. Which was written by NABARD to the bank.
There. You have,
Kamlesh
they have wrongly put it on there. Featured at serial number 20. Isn't this the number? Page 236, running page. State Bank of India, Kamlesh Kumar Surana.
Yes, your lordship.
Isn't it?
Kamlesh Kumar.
Go down.
Yes.
Assam, Dorong, so and so. What is the date of sanction is? 2/11/2018, na?
Yes, your lordship.
16. Isn't it? Mr. Doctor? No, the young. Whose affidavit I am reading? Respond number 7. Yes, your affidavit. Kindly come to page 12, annexure 3, capital A. At serial number 20
No, of the affidavit.
of the affidavit. Your affidavit. State Bank of India, Kamlesh Kumar Surana, Godown, Assam, Dorong, Storage, 2/11/2016.
276.
Isn't it the date? 2/11/2016.
Yes, 18. Lordship. It's 18.
2/11/2018.
Yes.
What is the date of the sanction?
It's 26/12/2016.
16,
Loan
na?
28/12/2016. Yes.
Huh? 2/11/2016. What is the date here?
11/11/2016.
What is mentioned out here, page 236 or internal page 12 of the affidavit? 2/11/2016. It is what I mean.
Date of sanction by financial institution. That a column.
It is relevant to take note of that in the list enclosed to the said communication dated 19/12/2017. The name of the petitioner featured as serial number 20. Full stop. It is further mentioned, next, it is further mentioned that a joint inspection of the unit of the writ petitioner was carried out. Wherein an officer from the respondent number 6 also featured in the said during the said inspection. And it was further mentioned that on 17/12/2018, a joint monitoring inspection of the unit of the petitioner was carried out by 3 officers from the respondent numbers 4, 6, and 7. And the report was recorded in a pro forma for the joint inspection committee duly signed by the 3 officers from the respondent number 4, 6, and 7. From from a further perusal of the affidavit, it is seen that the respondent number 7 categorically states that the petitioner herein is entitled to the subsidy of the total amount, which includes the advance subsidy as well as the final subsidy. Full stop. This court further takes note of that the respondent numbers 1, 2, 3, and 4 have also filed an affidavit in opposition. In the said affidavit in opposition, it is mentioned that the cutoff date for sanction of the loan under the scheme was 31/12/2016. Semicolon. The cutoff date of receipt of all projects by NABARD is 31/1/2017. And the cutoff date for sanction of the advance subsidy claimed by NABARD is 28/2/2017. The affidavit, the further affidavit of the respondent number 1 to 4 supports the stand of the respondent number 5 and 6. Inasmuch as at paragraph number 18 of the said affidavit, it has been mentioned that the action taken for recalling of the subsidy in the case of the petitioner is at par with the rights empowered to the concerned government organization as depicted in the operational guidelines of the scheme and the government interpretation of various terms of the guidelines from time to time is final. The report further reveals that on 13/6/2015, the respondent of number 7 had filed an additional affidavit wherein it has been mentioned that the petitioner was sanctioned a term loan by the respondent number 7 on 11/11/2016 for construction of the rural godown at Dhula, Dorong, Assam. And the petitioner had utilized the said loan by constructing the rural godown and had also repaid the entire loan amount to the respondent number 7 bank. And as a consequence of which the term loan account number 36291790882 stood closed on 8/3/2024. And in that connection, a no due certificate have also been issued by the respondent number 7 bank dated 10/6/2025, stating that there is no outstanding liability against the said term loan. It was further mentioned in the said affidavit that the term loan sanctioned by the respondent number bank was subsidy linked, and the respondent number 5 and 6 had released the first installment of the subsidy amount of rupees 16,03,800, and the said amount was credited to the current account of the petitioner. Bracket CA number 37303590537, bracket close, on 16/11/2017. The said amount still remains in the current account on being kept on hold by the respondent number 7 bank in compliance with the order dated 16/11/2018, passed by this court and extended from time to time. এই ওপৰত যেতিয়া লিখিব ন ৰিট পিটিশ্যনখন ফাইল কৰিছো বুলি তাৰপিছত এটা লিখিব upon filing of the writ petition this court issued notice returnable by 6 weeks and further directed as an interim measure that the respondent shall not take any steps for realization of the advance subsidy amount credited into the account of the petitioner. First, in the backdrop of the pleadings, this court have also heard the learned counsels appearing on behalf of the parties. The question which arises in the instant proceedings, the point for determination which arises for consideration, point for determination which arises in the instant proceedings is as to whether the petitioner herein can be debarred, as to whether the petitioner herein is entitled to the subsidy in terms with the ISAM in terms with the integrated scheme for agricultural and marketing, bracket ISAM, question mark. Number two, whether the petitioner, if otherwise entitled to, can be deprived of the benefit of the scheme on account of the lapses on the part of the respondent number 7 bank. And number three, to what relief or reliefs the parties herein are entitled to. Full stop. For the purpose of deciding the same, it is relevant to take note of that the integrated scheme for agricultural marketing was formulated with the following objectives.
These guidelines have been subsequently modified.
Huh?
This ISAM 2014 guidelines have been modified subsequently that I have shown to your lordship.
Where is that?
The page 191. The cutoff date is 27.
No,
Yes.
that I'm not on that.
Well,
I'm saying this, otherwise it is okay, na?
my lord,
The
this-
integrated scheme at page 264.
yes,
This is the objective.
this is the objective, but then this regarding cutoff date.
The cutoff date, and let me
Yes.
come to that.
Well,
First of all, let me say about the objectives. Whether he is entitled or not, therefore I have held, there are 3 points for
Right.
determination. So with the objectives, following objectives. এইটো পেজ 264 লিখি দিব এই অবজেক্টিভ 2 আছে পুট কৰিব নালাগে এইটো টিকটা লিখি দিব 1 অফ প্লাস 8 লেন It is pertinent to mention that on the basis of those objectives, the respondent number 1 and 2 had subdivided the ISAM, short for short ISAM, believe. ISAM into 5 components, the details of which have already been referred to here in above. You are concerned with agricultural marketing infrastructure, na?
Yes, sir.
One of the components is the agricultural marketing infrastructure. Chapter 2 of the operational guidelines of ISAM deals with agricultural marketing infrastructure. Clause 3.2 deals with the marketing infrastructure. In terms with clause 3.2.26, storage infrastructure like godowns, including standalone silos for storage of food grains with necessary ancillary facilities like loading, unloading, bagging facilities, excluding railway sidings, are eligible for subsidy. It further stipulates that assistance for storage infrastructure would be available on capital cost of the project, including cost of allied facilities like boundary wall, internal drainage system, weighing, grading, packing, quality testing and certification, firefighting equipment, etc., which are functionally required to operate the project. Clause 3.3 deals with who would be the eligible beneficiaries. In terms with clause 3.3.2, partnership, proprietorship firms, companies, corporations would come within the ambit of eligible beneficiaries. Clause 3.4 deals with the institutional lending. This aspect is relevant, taking into account that the subsidy which is to be given is linked to institutional credit and will be available to only such projects financed by banks, as mentioned in clause 3.4.1, NABARD, as mentioned in clause 3.4.2, etc. How, as next, the scheme further stipulates as to how the release, how the agencies would work for release of the subsidy, as mentioned in clause 3.5. It is relevant to take note of clause 3.5.1, which stipulates that the subsidy would be released through NABARD for projects financed by commercial, cooperative, regional rural banks, agricultural development finance companies, state cooperative banks, state cooperative agricultural and rural development banks, scheduled urban cooperative banks, scheduled primary cooperative banks, Northeastern Development Financial Corporation, other institution eligible for refinance by the National Bank for agricultural and rural development or any other financial institution such as state financial corporations approved by the DAC. Clause 3.6 further stipulates, as regards what should be the promoter's contribution and term loan in terms with clause 3.6.1, the minimum promoter's contribution should be 20% of the project cost. It further stipulates that the minimum term loan bracket including subsidy to be sanctioned by the financial institution bracket FI should be 50% of the project cost. Clause 3.7 deals with the subsidy pattern. In terms with clause 3.7.1, clause 3.7.1 deals with the subsidy pattern for storage infrastructure projects. In terms with clause 3.7.1.1, and more particularly in respect to northeastern states, Sikkim, UT of Andaman and Nicobar and Lakshadweep Island, hilly areas, the rate of subsidy would be 33.33% on the capital cost, and a subsidy ceiling have also been mentioned. Clause 3.8 deals with release of funds and subsidy. In terms with clause 3.8.1.2, NABARD is required to release the advance subsidy to the financial institution for keeping the same in the subsidy reserve fund bracket SRF account of the concerned borrower to be adjusted finally against the loan amount. This amount of 50% of the eligible subsidy would be released by NABARD to the FI on submission of the project profile claim form in Annexure Roman 9, complying to the sub-scheme guidelines. In terms with clause 3.8.1.3, the final subsidy would be released to the financial institution by NABARD after an inspection and recommendation by the Joint Inspection Committee comprising of officers from NABARD, financial institutions and the Directorate of Marketing and Inspection. It is further mentioned in clause 3.8.1.5 that a release of subsidy by NABARD to the financial institution would be subject to availability of the funds from the DAC. Clause 3.10 is of relevance, taking into account the dispute involved in the present proceedings. As such, the said clause is reproduced hereunder. Page 276. 3.10, the 3.10.1, 3.10.2. Editor. In terms with the above quoted clause, it would be seen that a financial institution would, within 90 days of the disbursement of the first installment of loan, submit to the RO, means the returning officer,
Regional
Regional office.
Regional
Huh?
office.
Regional office.
regional office, submit to the regional office of NABARD through its controlling oblique the nodal office a brief project profile cum claim form for advance subsidy in the prescribed form given in Annexure Roman 9, along with the documents as per the checklist at Annexure Roman 10. In addition to that, a copy of the claim form along with all documents should also be submitted to the regional office oblique sub office of the Directorate of Marketing and Inspection. The financial institution would also inform the promoter about submission of the proposal to the regional office, NABARD, and Director of Marketing and Infrastructure, NABARD, full stop. Thereupon, NABARD would in every quarter compile a list of all such proposals that have not been submitted in time and forward the same to the DMI, RO oblique SO, full stop. The regional office NABARD will also place the matter before the state level bankers committee, full stop. The state level banker committee will review all such matters and ensure that such delays do not recur and the proposals are received by NABARD within time. It would bold. The state level bankers committee would review all such matters and ensure that such delays do not recur and proposals are received by NABARD within time. Full stop. Clause 3.10.2, however, is not relevant for the purpose of the present dispute. It is pertinent to mention that Though clause 3.10.1 did not specify the time limit in respect to those projects sanctioned by the financial institution in terms with the guidelines issued by in terms with the above guidelines, which came into operation with effect from 12th of March 2014. But subsequently, by the what is this document? But subsequently, the NABARD, that is the respondent number 5, issued a communication, issued a circular number 285 oblique DOR dash 67 oblique 2016 dash 17 dated 9/12/2016, whereby had issued a circular number 248 oblique DOR oblique 64 oblique 2016 dash 17 dated 21/10/2016, whereby the last date whereby it was intimated about the stoppage of the sanction of subsidy linked term loan for new projects with effect from 31/10/2016. Subsequent thereto, by another circular number 285 oblique DOR 67 oblique 2016 17 dated 9th of December 2016, it was intimated that the Ministry of Agriculture and Farmers Welfare had by the letter dated 5/12/2016 had extended the cutoff date for sanction of subsidy linked term loan for new projects for all category promoters in the northeastern region by financial institution under the AMI oblique sub scheme of ISAM up to 31st of December 2016. And accordingly, it was therefore mentioned by the circular dated, said circular dated 9/12/2016, that the cutoff date for the financing bank for submitting all such advanced subsidy claims to NABARD was extended from 30th of November 2016 to 31st of January 2017. It is on the basis of this circular dated 9th of December 2016. The respondent number 5 and 6 have taken a position in the in respect to the case of the petitioner, that the petitioner in the position in the case of the petitioner, that as the State Bank of India, that is the respondent number 7, had submitted the claim for the advance subsidy after 31st of January 2017. The petitioner's claim for subsidy cannot be granted. And as such, the petitioner was not eligible. First, this would, in the present facts, it would be seen that in terms with the operational guidelines, which were issued on 12th of March 2014, the petitioner is an eligible beneficiary in terms with clause 3.3. And the petitioner having taken a term loan from one of the banks as mentioned in clause 3.4.1, for the construction of a storage infrastructure as mentioned in clause 3.2.6. Was otherwise eligible for the subsidy. In addition to that, it would also be seen that the total cost of the project for construction of the godown in question was rupees 1.20 crores, which is an admitted position. And apart from the 80 lakhs, which was the term loan, the remaining amount have been spent by the petitioner, isn't it? And as such, the petitioner also is eligible in terms with clause 3.6.1 of the operational guidelines. In terms with the said subsidy link, the petitioner is entitled to subsidy on the capital cost to the tune of 33.33% as mentioned in clause 3.7.1.1. Full stop. The record further reveals that the petitioner have petitioner's term loan was sanctioned on 11/11/2016 prior to the cutoff date for submission of the claim. Full stop. This court further finds it relevant to take note of that clause 3. That the operational guidelines which was announced by the office memorandum dated 12/3/2014 did not have a cutoff date in respect to those applications which were filed in terms with the new guidelines which came into operation with effect from 12/3/2014. Isn't it?
Okay.
There's no cutoff date here.
Yes, Your Lordship. In 3.10, there is no cutoff date mentioned.
Huh?
In 3.10.1, there is no
Where is the cutoff date?
cutoff date was not mentioned.
However, the cutoff date was only mentioned in respect to all projects sanctioned by the financial institutions under the previous guidelines. Okay, let me come back. Find out if there is any cutoff date. Cutoff date is there.
Only 90 days.
90 days.
This was of.
There is no cutoff date.
No, the only thing is that, that 5/12, that the limitation of that, it has to be before 31st of January 2020.
This is by NABARD.
That by secretary process. And, marketing process, government of India.
Where? Where?
The, what's the page number? Page number 189 of the meeting. But the process has recorded it.
No, that is another, that is by NABARD.
That is, Ministry of Agriculture.
Ah, this one.
Ministry of Agriculture.
Who's-
And that has come also in the night, source of the power is that also, also this page number 72 also. Of the repetition, 72 point number change. That is the source of the power, where government reserve the right to modify and alter. Modify that and delete any transfer from the system. Of the scheme. Page number 72 of the scheme. Of the repetition. Point number 10. So under this power, that letter has come into existence. Otherwise, this case was in process that 90 days here, within 90 days here. But under this power, this letter has come to existence and government has modified.
Let me come back. What is your judgment you are referring to?
Not referring any judgment.
Any judgment? Would answer the first point for determination as to whether the petitioner is eligible in as much as the facts in hand read with the operational guidelines which came into operation with effect from 12/3/2014 would show that the petitioner is eligible for the subsidy claim. Now let this court take up the second point for determination as to whether the petitioner is entitled to. Let this court take up the second point for determination. As to whether on account of the respondent number 7 having not submitted the subsidy claim for claim for the claim for advance subsidy within 31/1/2017, the petitioner can be deprived of the subsidy. In the foregoing paragraphs of the instant judgment, this court have duly quoted clause 3.1.0.1, which stipulated that the financial institutions were obligated within 90 days of the disbursement of the first installment of the loan to submit to the regional office NABARD through the the nodal office a brief project profile claim form for advance subsidy in the prescribed form in Annexure Roman 9, along with the documents as per the checklist at Annexure 10. First, it further stipulates that in the circumstance the financial institution have delayed, the state level bankers committee would review all matters and ensure that such delays do not reoccur and the proposals are received by NABARD within time. This makes it very clear that in the circumstance the financial institution have delayed, the beneficiary of the subsidy should not be affected on account of the lapses on the part of the financial institution. This court further finds it relevant at this stage to take note of Annexure Roman 10 to the said. Where is that Annexure Roman 10?
Yes, 71.
Annexure Roman 11
180, 11, 181.
of which is a part of the operational guidelines. Stipulating the instruction for the promoter to be annexed by the financial institution with the loan sanction letter. The said guidelines, said instructions also do not mandate any cut-off date. The respondent numbers 1 to 4 relies upon clause 10. Taking into account its relevance, the same is reproduced herein under page 72. From a perusal of the above quoted clause, it would be seen that the government's interpretation of the various terms of the guidelines would be final, and the government reserved its right to modify, add, and delete any term and conditions and restrict or stipulate any provision without assigning any reason therefore. On the basis of the said communication, on the basis of the said clause, the respondent numbers 1 to 4 contend that the communication dated 5/12/2016 was issued by the agricultural marketing advisor to the government of India, whereby was issued to the respondent number 5 and 6 by the agricultural marketing advisor to the government of India, whereby it was mentioned, whereby reference was given to a communication dated 2010-2016 regarding stoppage of sanction of the subsidy-linked term loan for new projects by the financial institutions under the Agricultural Marketing Infrastructure Sub-Scheme, ISAM, and further conveyed that the cutoff date for sanction of the subsidy-linked term loan for the new project of SC/ST category promoters and all category promoters in the northeastern region by the financial institution, including NCDC bracket close under the Agricultural Marketing Infrastructure Scheme of ISAM in the remaining period of the 12th plan is extended up to 31st of December 2016. It was further mentioned that the cutoff date for receiving and sanctioning of all advance subsidy claim by NABARD is also extended up to 31st of January 2017 and 28th of February 2017 respectively. This court further takes note of that this communication was addressed to the respondent number 5 and copy thereof were issued to various authorities, but not to the financial institutions. Subsequent thereto, on 9th of December 2016, the respondent number 5 issued a circular dated number 285/DOR 67/2016-17, thereby intimating all the financial institutions, including the respondent number 7, about the cutoff date for the financing banks for submitting all advance subsidy claims to NABARD was extended from 30th of November 2016 to 31st of January 2017. Therefore, the respondent number 7 at best would have knowledge about the said, but not the petitioner. It is further relevant to take note of that the operational guidelines which came into operation with effect on 12/3/2014 obligates the financial institution who had issued, as in the instant case, a term loan linking with the subsidy to hand over to submit the proposal within time. More so, when the respondent number 7, in terms with the circular dated 5/12/2016, was aware about the extension being granted to a particular date. The record reveals
They're not ever.
it is being issued. You cannot say you are not aware. It is being issued to the chairman managing the all scheduled commercial banks. How can you say that? If you say that, it will have more consequences upon you. Under such circumstances, it is therefore the opinion of this court that on account of the lapses on the part of the respondent number 7 to submit the proposal to the proposal in terms with clause 3.10.1 to the respondent number 5 and 6 within 31/1/2017. That too when the first installment of the loan was disbursed on 29/12/2016 cannot be said that it was a fault on the part of the petitioner. Under such circumstances, it is therefore the opinion of this court that the respondent number, that the petitioner herein cannot be deprived of the entitlement in terms with the subsidy, in terms with the this agricultural marketing scheme. What is the name?
Agriculture Marketing Infrastructure. ISAM.
In terms with the
Integrated Scheme of Agriculture Marketing.
agricultural marketing infrastructure scheme. Subsidy in terms with the agricultural marketing infrastructure scheme. On account of the lapses on the part of the respondent number 7. This answers the second point for determination. Next. The third point for determination is what relief or relieves the petitioner herein will be entitled to. Next. It is the opinion of this court that as the petitioner herein, as the admitted facts herein show that the petitioner was eligible in terms with the subsidy scheme, eligible in terms with the agricultural marketing infrastructure, in terms with the operational guidelines pertaining to the agricultural marketing infrastructure scheme for the subsidy. The petitioner herein is entitled to the said subsidy. On account of the fault of the respondent number 7 to submit the same within time cannot deprive the petitioner of his entitlement. This court further takes note of that the communication dated 5 further takes note of that these operational guidelines on the basis of which the petitioner has claimed his right to be entitled to the subsidy scheme is being taken away on the basis of certain communication issued by the respondent number 2, who is the agricultural minister officer, is the respondent number 2 or 3. Yes, Mr. Counsel.
Two, Your Lordship.
Where the
Ministry of
respondent number-
Agriculture.
Respondent number
Ministry of Agriculture.
at the instance of the agricultural marketing officer to the government of India, writing a letter to the respondent number 5, and thereupon the respondent number 5 issuing a circular only in connection with only to the various financial institutions. The petitioner herein, who otherwise have changed and altered his position on the basis of the scheme, was never notified, and as such, a promise so held out cannot be taken away in the manner in which it has been sought to be done. Next. Accordingly, the incident with petition therefore stands disposed of. I'll put next article. This court further finds it pertinent to take note of that the respondent number 7 is a public. What is that? State Bank is a public. The public sector bank. And the respondent number 7 is a public sector bank. And the respondent number 5 is a, what is that?
I wish, my lord, National Bank for Agriculture and Rural Development.
What is that? It's a public sector. That is also a public sector.
Yes, yes,
bank.
yes, public sector.
Is also a public sector. The respondent number 5, 6, and 7 are public sector banks. First. The respondent numbers 1 to 4 a public sector bank. It is therefore the opinion of this court that the said respondent number 5, 6, and 7 has to take appropriate steps in consultation with the respondent numbers 1 to 4 so that the subsidy to which the petitioner is entitled to is being disbursed. More so, taking into account that the respondent authorities, in terms with the operational guidelines, have carried out a joint. What is that joint? Joint inspection survey, and found that the petitioner have utilized the term loan for the purpose for which it was issued. Taking accordingly, the incident with petition stands disposed of with the following observations and directions. Number 1, the petitioner herein is entitled to the subsidy in terms with the operational guidelines dated 12 subsidy in respect to the agricultural infrastructure scheme, agricultural marketing infrastructural scheme. As made operational on the basis of the office memorandum dated 12/1/2024, 14. Number 2, the respondents 5, 6, and 7 are directed to do the needful so that the subsidy amount which the petitioner is entitled to is disbursed at the earliest and preferably within 4 months from the date of the present judgment in order. Number 3. This court further directs the respondent numbers 1 to 4, the respondent number 5 and 6, 5, 6, and 7, also to take up the issue with the respondent numbers 1 to 4, who have issued this circular, under whose aegis the subsidy scheme was announced, made, and thereupon take effective steps so that the petitioner is disbursed the amount of subsidy to which the petitioner is entitled to within the period above mentioned. With the above, the instant petition starts.
Now, let's,
Absolutely. मैं ऊपर to बदला नहीं बोलता, CKS बोलो. APS for respond numbers 1 to 4. I see. What are these IS for?
Your Lordship, the eyes were filed for vacating the interim order.
There was
So
an
vacating the-
interim order by the court lordship that not to recover the advance subsidy amount because that has already been credited in his separate SBI account. So for vacating that.
My lord, here in this case, my lord, against the affidavit in opposition, we have filed reply, my lord, yesterday. That is not on the record also, my lord. That is against the transfer of the consumers from my fair price show during the suspended period, my lord, and appeal is also pending. my lord. And today, my lord, item number 14 also listed, my lord.
What is your case?
My case is that during pendency of the appeal before the authority, my lord, my consumers were transferred, my lord. My license was suspended, my lord. And we have also challenged, my lord, appeal also. Today's supplementary list item number 14, my lord.
Yes. What, why the appellate authority have not yet decided?
My lord, already decided, my lord.
Already
Already decided, item
appeal is
today's-
disposed of lordship.
Today's list, my lord, item number 14, my lord.
supply item
That is
lordship
listed. Supply 14. Supply 14, my lord.
14 to the,
So this has become infractions lordship. So first, their basic prayer was, they have not deciding the appeal lordship.
That is not, my lord, against the transfer, my lord. During pendency of the appeal. And appeal has been decided by the authority, by appellate authority. There is a no show cause, my lord, in suspension order itself.
so into item number 2.
14, my
Mr.
lord.
Swanflo submits that the repetition has become infructuous. Accordingly, the repetition stands closed. Yes, item number 14.
14, my lord.
SR Burwa appears for the response. Yes, what is your case?
My lord, I have challenged the appellate order, my lord, in this. case,
Why?
my lord. Appellate order is page 139, annex 32, my lord. The allegation is that, my lord, I have contravention, there is a contravention of APDA order, my lord, as well as targeted distribution order, my lord. Stay as well. They will stay as well. Nice, he didn't put everyone. Stay so good. That way, I didn't get it close and ask him, "Sir, we don't need to cover that." As it is to be good. We nothing to get close. It will open up.
You have filed an appeal against the suspension order.
My lord,
I'm not on that, but what have you done is regards, how, you can't keep a thing for suspension for more than 3 months. That's as per 15.2.
my lord, 15-2. 15-2, my lord, the PDA order.
How do you do it?
And my lord, your lordship may kindly peruse the
You have
suspension
to
order.
take a decision, Mr. Borua, you have to take a decision out there as to whether any action is required to be taken. This is on an appeal. What has happened to the disciplinary procedure, the proceedings? Have you issued a show cause to him or not?
No, my lord,
Then,
no show cause, my lord.
then how can you continue?
My lord, your lordship may kindly peruse the suspension order is at page, my lord,
My goodness.
page 83, my lord,
Page
83. That is type copy, my lord, and 87 is the, my lord, original copy. There is a no show cause, my lord, in the suspension order itself. In fact, my lord, against me, there is a no complaint. At the endorsement of the deputy commissioner, which I have also annexed, my lord, my license has been suspended.
This is okay, show cause notice, where is your show cause?
There is a no show cause, my lord,
Then
only suspended, my lord,
how can you continue?
on 22nd July, my lord. Till date, and my shop is also sealed, my lord. My shop is also sealed by them, my lord, by the authority. On 19th, my lord, your lordship, another letter is from the authority, my lord, suspending the subdivisional officer, my lord, your lordship, page at page 70, there is a no complaint against me. After 2 days later, they have suspended my license. Page 73, your lordship. Second,
Yes.
But some interim order was also operating in this case, lordship, earlier.
Your lordship,
Interim
package-
order, I will extend it. It is a different
No,
thing,
it was
but the
taken.
fact that it seems the government advocates are not aware of the provisions of the Assam distribution of public distribution of order 1982 or 83.
my lord, I have a copy.
No, don't give it to me. Give it to Mr. Burwa. He seems to be not knowing what is clause 15. Read it.
15 to
First of all, this person has been fighting tooth and nail against the suspension. But surprisingly, you have not. How do you take care of 15-2? Tell me.
lordship.
Yes, 15-2. How do you take care of it? Can you keep a suspension beyond 90 days?
That cannot be done.
This has to go.
Lordship, I will obtain instruction or I will produce a record whether that show cause was issued or not. Because from the pleadings, it apparently it is seen that the show cause was not there.
Thursday.
my lord, your lordship may peruse the this honorable court's order, my lord.
Thursday.
Lordship.
In that case, I will, my lord, division bench order, my lord, against the suspension order, we have approached before this court, this honorable court, since there is a no show cause notice issued against me, my lord. This honorable court asked me for alternative remedy. Accordingly, we have against the challenge this, my lord, in data bill number 297. And the honorable division bench directed us to approach before the appellate authority. And the appellate authority passed this order, my lord, without revoking the suspension order.
I know that.
My-
Only thing is whether they have issued a show cause, that is what I am asking.
My lord,
So I am having it on Thursday.
my lord.
Tomorrow, if I don't give him an opportunity and I set aside all these orders, he will get an opportunity of filing an appeal and
Right.
tell their division bench out here, look here, this particular judge doesn't give us an opportunity.
My lord.
Now, heard Mr. So-and-so appearing on behalf of the petitioner. Mr. S.R. Burwa appears on behalf of the respondents. The petitioner herein have assailed the continuation of the suspension order of his Fair Price shop with effect from
22nd July. 2nd July, my lord, 2024.
22nd of July 2024, 24th of July. 24th, huh?
My lord, 22nd, my lord, in the letter itself. That page 87.
With effect from 22nd of July 2024. The learned counsel appearing on behalf of the petitioner submits that without going much into the merits, the fact that there there has been no issuance of any show cause proceedings, the continuation of the suspension order beyond a period of 90 days is beyond the powers conferred upon the authority in terms with clause 15(2) of the Assam, what is the name, full name?
Assam Public Distribution Order 1982.
Mr. Asansol submits that
Articles
he
of order.
produced the records on Thursday.
Records lordship Thursday, it will be difficult for me, it has to be come from Kachar. Then I'll obtain an instruction.
They can call for a scan copy also, my lord. Nowadays, it's will
Would produce the instruction
Lordship,
as to whether any show cause notice was issued by Thursday.
lordship.
And if so, when it was issued and what is the stage of the show cause proceedings on Thursday? List the matter on Thursday, next day, at the top of the list.
My lord, my lord, for item number 2, that was not my lord. In fact, he has wrongly submitted for your lordship, my lord. My prayer is different, my lord. That is not in fact, it's related to this appeal, my lord. But during pendency of the appeal, my consumers were transferred, my lord.
Consumers are transferred, not your fair price shop. Consumers has to be transferred. Otherwise, what will happen to the consumers? Tell me.
They were tagged with the another fair price.
Understood, but the fact that anything happens out there, that will be taken care of by this court.
My,
You may have to file a writ petition for that.
my,
And item number 2 to Leco, Mr. So and so.
Lordship, one order,
It may be
14 to 25, not to take, 14 to 25, one order was there. Not to take any coercive action, added against the petitioner, lordship.
In this petition. in
Yes,
the
yes,
present
yes.
petition.
which petition?
14 to 20.
Or 7?
Which petition?
That was already vacated, your lordship.
I vacated it last time.
My lord,
Last time.
your lordship got it at court.
Yes, so that is, he cannot refer it to Mr. So and so appears on behalf of the petitioner. And Mr. So and so appears on behalf of the respondent. The grievance of the petition is that while the appeals is pending against the suspension order, the respondent authorities are taking steps for the purpose of we're taking steps for
Transfer,
to detect
my lord.
the what do you say there? And the license holder, or what is that? The
Fair price,
no, what do you mention? What is the term used for the customers?
beneficiaries.
Beneficiaries.
The beneficiary, detect the beneficiaries attached to the petitioner's shop to some other fair price shop. Taking into account that in the meantime, the appeal has already been disposed of, whereby the appeal of the petitioner has been dismissed. It is the opinion of this court that the grievance of the petitioner herein in the present proceedings cannot be allowed to be, it is the opinion of this court that the grievance of the petitioner, opinion of this court that any order passed after the appeal of the petitioner have been dismissed would go against public interest in as much as the beneficiaries would be affected on account of the continuation of the suspension of the petitioner's fair price shop license. Considering the above, this court, at this stage, however, it is pertinent to mention that the petitioner have assailed the order passed by
Appellate.
The appellate court in WPC numbers, it's second.
My lord, WPC number 735/2020.
Of so and so. Push. Under such circumstances, this court is not inclined to entertain the present petition. And depending on the relief so granted, appropriate orders, depending on the relief so granted in WPC, the second common proposal,
735.
appropriate orders would be passed if in the circumstance, the beneficiaries of the petitioner are detached
My lord,
from his fair persons. According the writ petition stands closed with the above observations. So then first, the number 2 gets closed.
My lord.
Number 4, on
Thursday.
Friday, on Thursday, you'll get an order.
My lord. Obliged, my lord.
What is this?
Pursuant to the order dated 22nd of August, the,
Oh, this one, the consultant.
yes, the affidavit has been filed yesterday at 3 p.m. That is not there, and we request 2 weeks' time to file a reply to that. Because some report of expert committee has been annexed with the affidavit.
You are who?
I am not a safety consultant. I am safety consultant,
What consultant?
safety consultant.
Safety.
Safety.
And he?
I am the proof consultant. I'm the proof consultant.
Proof consultant.
Proof consultant.
And they have taken actions of
Against me.
blacklisting both of you
Others also,
because some breeze fell down.
yes,
You have got an interim order.
yes, sir.
He does not. So his interim order would be considered today. What do you have to say?
It's for last subject, was it? It's not in the record, was it? So, so these are things, it's really liable in this case. So against the left side. So
Huh?
I will be taken up next Tuesday, what's it?
Madam, tell me, why he would also not be entitled to a similar relief? What relief he has got? You have not filed a vacation against him. So understand why he should not also be entitled to a similar relief, because after all, these are, on the face of it, there was nothing. But without giving an opportunity to the respondent to pass an interim order, I normally don't do. The earlier judge was more kind enough to give it to him. Although I'm not saying that he's entitled to the full relief, both of them. But why not he be given a relief which is parametric to him, as he have not filed a vacation? So we pass a similar relief. Only the interim, that direction, because they both of them stand in the same footing. One is a group consultant,
Safety consultant.
safety, and the other is the group.
Proof. And that is.
And
prior to commencement of work.
his work finishes after giving the design. His work is only limited to consultation and also to see that the design is placed before the project engineer at the earliest.
Yes.
That too prior to commencement of work.
And after the commencement of work, nothing remains. He is like a messenger.
The
How to
design
take-
consultant also, other consultant also. Because he has to
Chalo.
check. So, you know.
Anyways, here you have filed affidavit, na?
In both the
Yes.
cases.
Cases also they filed a little bit, but it is not put the record. In both the cases.
Miss Arbora, the standing counsel of the National Highway Authority of India submits that their affidavit in opposition has been filed in the present petition, and a copy thereof has been furnished to Mr. Adhor, the learned standing PT counsel for the petitioner. Mr. Adhor submits that he would like to, he would take instructions and if necessary, file the affidavit. File an affidavit in reply. Full stop. Mr. Dekar, you were appearing in this petition also.
I was earlier.
Now you have changed. Taking into account the above, list this matter again on. We are having an interim order on 11th of November 2025. In the meantime, the reply be filed by 4th of November. Interim order passed earlier shall continue till then.
Interim order was still disposal probably. Interim order was.
Where? Paragraph 12 of that order, the above observations have been made only in connection with the prayer for Iman. The interim that is passed today in the present year shall be reconsidered after pleadings in the matter
Paragraph
are
11.
completed.
Paragraph 11, madam.
What is that?
Order dated 24th of July 2025.
Then what do you say about 12? Till the next day. It will be. Mr. P.S. But Mr. P. Here you have not filed affidavit, na?
It's fine.
In here also affidavit filed.
Filed, but yesterday only, but the statement was given that it will be filed on or before 8th of this month.
So
Anyway, however,
Mr. P.S. Dekar, the learned counsel appearing on behalf of the, heard Mr. P.S. Dekar, the learned counsel appearing on behalf of the petitioner, Ms. R. Bora. Mrs. R. Bora, who appears on the standing counsel, who appears on behalf of the National Highway Authority of India, and Mr. K. Gogoi, who appears on behalf of the Central Government Standing Council, Central Government Council, who appears for the central government. Today, the matter is fixed for. It has been submitted that an affidavit in opposition has been filed yesterday
No,
by the
last Thursday,
last Thursday you filed.
Thursday.
served on me yesterday. It was said yesterday.
But I.
Hmm.
Last.
Affidavit in opposition has been filed by the respondent NHAI. The petitioner, the counsel for the petitioner submits that a copy thereof have been only filed, only served upon him yesterday.
Yesterday.
He therefore submits that he requires some time for the purpose of taking of instructions as to whether any reply is required to be filed, and if necessary, the reply would be filed. Mr. P.S. Dekar, the learned counsel, further submits that the petitioner hearing stands on the same footing as the petitioner in deputation number 2. It stands on the same, if not better footing than the petitioner in deputation number 3647 of the 2025, who have all, the learned counsel submits that the learned coordinate bench had passed an order on 24/7/2025, thereby granting an interim stay to the order of blacklisting.
Yes, yes, yes.
dated
9/6.
9/6/2025. He submits that the petitioner herein, who was only a proof consultant and who had no role after the construction of the bridge started, should also be given a equal, should also have no role in the construction of the bridge, is also entitled to, ought to be also passed a similar order, thereby staying the impugned order
Annexure 7, dated
dated
9/6,
impugned order dated
page 344.
dated 9/6
9/6.
2025. Full stop. Mrs. Arbora submits that the interim order which was passed in WPC number 3647/2025 is continuing. And in that case, the petitioner was appointed as, what is that?
Safety consultant.
Safety consultant. She further submits that in the instant case, the petitioner was engaged as proof consultant. This court, having taken into account the various clauses of the tender documents and further having perused the order dated 24/7/2025, whereby the learned coordinate bench had passed a stay and an order and interim directions in the case of the petitioner in WPC number 3647/2025, is of the opinion that the petitioner in hearing is also entitled to a similar relief till the next date. Accordingly, the impugned order dated 9/6/2025, whereby the petitioner was blacklisted for a period of 1 year with effect from 9/6/2025 to 9/6/2026, stands would remain stayed till the next date. List this matter again on 11th of November. What did I fix? 11th of November 2025, along with WPC number 3647/2025. The petitioner is given the liberty to file the reply on or before 4th of November 2025. The interim order as stated above shall continue till 11th of November 2025. This court further takes note of that the period of blacklisting is for a limited period of 1 year. And as such, there is a necessity for disposal of the writ petition at the earliest. As such, an attempt shall be made to dispose of the writ petition on the next date.
Hurry up, Mr.
Item 6.
Yes.
Your Honor, can be day after tomorrow, Lordship. Matter will be taken. Matter will be taken day after tomorrow, Lordship.
I don't have the time for this.
Lordship, conducting counsel S.H. Sikdar is out of question today, Lordship. And today itself, I have filed the opposition reply, affidavit in reply, Lordship.
Rob Lots is over.
No matter.
Why?
That is because of pendency of the state petition, they do not proceed now.
What is his case?
Only my lord issue is my lord, the reject, their offer has been rejected because my lord, as per the guidelines, who particulars, my lord, that
Any
is,
judgments? Who patta does it has to be in annexure, particular annexure, na?
Right.
Annexure 3 Romani. Isn't it?
my lord, there are
There-
two particulars, one has executed the lease deed, another other has not.
And the other co-patta has to give an undertaking.
Oh, well, as per the guidelines, both are my lord required to my lord.
No, no, if it is
execute the-
not done also,
My,
the other person has to give an undertaking. Is there in formal PA?
this is my lord regarding my lord,
Where is that?
clause 4, subclause 6 of the guidelines.
Clause?
Clause 4 of subclause 6. Clause 4, subclause 6.
Where do I
Point
find
A.
it? Yeah, appendix 3.
Yes.
You see this appendix 3 on sent letter in the form of affidavit for members of the family. This is somewhere for group 2 now, here. The landowner, no, page 24G. The land owned by the family members will also be considered as belonging to the applicant subject to producing the consent letter in form appendix 3.
This is not relates to, my lord, the land offered by the family members. The applicant is different and the land is in a different person. This clause is not applicable in this particular case. ma'am.
Then in that case, where is it mentioned that all persons have signed?
My lord, clause 4, sub-clause 6.
What?
Applicable to all categories, page 23.
Then where?
My lord,
In case the land offered by the AI is one found not suitable or meeting AI, then the AI group 3 and AI so and so. To be available for Iman on a minimum area from the date but not later than the date. If the offered land is on a length that there are multiple owners, then lease deed should be executed by all owners of the offered plot. In case lease deed is not executed, such deed shall be treated as invalid.
my lord, that is the reason for rejection.
Finish.
Lordship, before passing any order, my lord kindly heard the conducting council. I am not the conducting council in this case,
Who
Lordship.
are you?
I am on behalf of SH Sigdar, Lordship.
Where is he?
His letter of absence is there, Lordship. He is now out of student today, out of my lord, city, Lordship, today.
Till when?
But today only, Lordship.
We have it when? Day after?
Day after tomorrow, Lordship.
Finish it.
Sure, Lordship.
Your would be ready? Your
Lordship.
reply will be ready?
Yes, Lordship.
You will file the reply by tomorrow?
No, Lordship. Today itself I have filed.
You are filing the reply today,
Yes,
so we'll have it day after,
Lordship.
2 o'clock.
Lordship.
Whether your senior would be available,
Lordship. Available.
ask him to be available,
So,
or you prepare it.
Lordship.
Fantastic. Ms. So-and-so appearing on behalf of the respondent, the petitioner submits that the petitioner is in the process of filing the affidavit in reply today. First of, Mr. D.K. Sharma, the learned counsel appearing on behalf of the IOCL submits that on account of the interim order, the respondents are not in a position to allot the retail outlet to complete the formalities as regards the allotment of the retail outlet. And as such, it submits that there is great urgency. Taking into account the above, list this matter, or not 18, not possible. On 19th of September at 2 p.m. The interim order passed earlier shall continue till then. The registry shall bring on record any further pleadings so filed in the meantime. Oh, yes.
Supplementary item 13.
Yes, what is this?
Lordship, the matter as such relates to payment of the utility contractor's bills.
What?
The Utility contractor, basically,
Contractor bill.
yes, Your Lordship. It was
Then?
this,
Where's the other side?
Mr. Talukdar, he was just here. And
Who is Mr. Talukdar?
he is the standing counsel NHIDCL and also the private respondent is.
Non-payment of dues, go there, have an arbitration.
The Lordship, there is not, because we don't have any arbitration clause in this issue.
Then what do you have?
We don't have it.
Petition.
That's why.
By
That's why.
settling the accounts with the parent, the amount to which has been claimed by the petition, namely so and so, should be secured and no such payment be made without the leave of the court.
If I may
As
just.
per
take
nine,
some
the
time,
employer was required to cause shifting of any utility to an appropriate level or a line so and so. Material claimed that it was engaged by the contractor for such utility work as a matter result of which they have raised bills. So some part of the bill was made at the initial amendment part of the. So you don't have anything with NHIDCL?
Not
Have
directly
the third party.
with that particular,
Go and fight it
But-
before the civil court.
that is what your lordship, that is a one catch. The conduct and also one particular clause. The otherwise, I would have said there is no privity of contract. I wouldn't have approached the honorable court under 226. But what has actually happened, if I may just state the facts right from the beginning, your lordship, then everything will be clear. Your lordship, what has actually happened, a particular contract was executed between NHIDCL and TK and Ramki joint venture. Now, according to that particular contract agreement, there is a particular clause 9.2. Now, in terms of clause 9.2, if I may take your lordship to page number 38, clause 9.2 of the contract agreement, 38. Shifting of obstructing utilities. Under article 9.2, I'm sorry.
Shall in accordance with the applicable laws and here for shifting of any utility pipes so and so the actual cost of shifting is approved and communicated by the entity owning the utility shall be paid by the contractor and reimbursed by the authority in the event of any delay in such shifting by the authority entity owning the utility beyond the period of so and so date so and so.
So here, the utility owning agency, here the contractor, the petitioner is a empaneled contractor with APDCL. Now, APDCL.
Ah.
Now, since it was regarding shifting of electrical poles. Now, what has actually happened, the APDCL, the utility owning agency has to be satisfied and approve the whole work because the private respondent is a road contractor, road construction company. It is not in any way related to utility shifting and again, setting up the utility owned by the utility owner, that is APDCL. Now, in terms of this particular clause 9.2, first the utility, the contractor has to engage a utility, the contractor empaneled with a utility owning agency who will shift the utility, be it electrical pole or a water pipeline or any other utility, which is obstructing the highway. Now, after that utility owning agency satisfies the work to be completed to the satisfaction of the utility owning company.
Where is it mentioned that he would have to, engage somebody else?
The utility owning agency, your lordship,
Where?
the actual cost of shifting as approved and communicated by the entity owning the utility shall be paid. Now, the
Approved and communicated by the entity.
entity owning the
The
utility.
utility.
So APDCL will
Actual
obviously,
cost of such shifting as approved and communicated by the entity owning the utility means APDCL.
APDCL. So they will have to engage a contractor which is
Shall
empaneled
be
with.
paid by the contractor and reimbursed to the
By the
authority
authority.
to the contractor.
By the authority to the contract.
So how do you come into the scene?
Your lordship, I am that particular agency who, I am empaneled with the utility owning agency.
So
I have completed and this has to be satisfied by the authority owning that utility.
not.
And to the, also to the, and also.
Go to the civil court.
Also, your lordship, the conduct is there, your lordship.
There is no conduct business.
Why, your lordship, I'll
Go
take
to
your
the
lordship to
civil court.
page number 42.
No, this is not a case. And mister, you don't pay, you are paying?
Lordship, we are paying to the contractor, Lordship, they will, they have to submit the reimbursement bill, then we can pay them, they will.
Have the contractor submitted it to you?
No.
No, they have submitted. It has.
Lordship, they have to submit the reimbursement bill, I have received the
They have
instruction.
The
also.
contractor has to submit that he has paid.
Pays. That's
And
what-
then only they will.
Yes,
But that's what I am on the conduct one.
So
Earlier,
that
the
is,
first,
you are asking a writ to be issued by this court upon the private respondent who has no business.
yes,
That he should submit a particular document to him
your lordship,
after making payment to you.
your
Now,
lordship,
the fact that whether you are entitled to the payment or not, why should we?
your
On
lordship,
the basis of a private person, it's a pure and civil case or civil court.
your lordship, I draw my argument on the basis of section 70 of the Contract Act. On the prin-
70 for the contract before that. Supreme Court.
on the
Before the Supreme Court.
principle of quantum merit. What actually,
How do we know that you have done the work?
your lordship, any third party, the authority, they have now, the road is completed, they're enjoying that particular. road.
How do we know how much you had spent?
Your lordship, it has been approved. I'll take your lordship. to
By
that.
whom?
By the authorities engineer. Authorities engineer
They may
certified.
approve it. Authority may approve the work, not the amount.
No, the amount also.
How can they approve?
Your lordship, as per the contract terms, as well as the foreclosure agreement between the.
The clause 9.2 does not conceive of that.
Your lordship, if the actual cost of such shifting, your lordship, that actual cost of shifting has to be approved by
I
the
have
utility.
understood APDCL making the claim. Because here it says the actual cost of such as approved and communicated by the entity.
Yes,
As approved and communicated by that is by APDCL.
yes,
Owning the utility.
yes,
Shall be paid by the contractor.
yes,
And reimbursed by the authority to the contractor.
yes.
So therefore, if APDCL tomorrow says that this is the amount, this amount shall be paid by the contractor.
Yes. That has
And
been.
then the contractor would be reimbursed.
Mm.
Now here is a case that the contractor has not paid.
Your lordship, that is what.
So you want this court to issue a writ upon the contractor to make payment.
Your lordship.
Why should I?
Your lordship, here the authority owning that particular utility has supervised and approved that the works has been completed.
Go case.
Your lordship, that is what has
Dismiss it
actually
at
happened.
2 o'clock we'll dismiss it.
Lordship, if I may take your lordship to.
No, not necessarily.
the
This
pages
can
and
use
also,
of-
also one more aspect, your lordship. One more aspect, your lordship. The contractor themselves, they have given an undertaking to the NHIDCL to that effect that you pay directly, since we are actually facing financial problems. You pay directly to the
That is
utility
not the
contractor.
term of the contract. Are you going to pay?
Lordship, they have to submit the reimbursement bill. I've received the instruction also, Lordship. We
Means.
cannot directly pay, Lordship. If
Your
Honorable Court
specific-
directs, then we
Your
can-
specific standing that look here, he will pay. After he pays, you are going to pay.
Yes, Lordship.
But the fact that you are not inclined to pay directly to.
Yes, Lordship, that is instruction.
Then
If,
over. That's the question.
Your
Lordship,
lordship,
otherwise they are entitled, Lordship.
You want this court to change the terms and conditions.
No,
During the lunch hour, prepare another clause. What you want, we can incorporate it in our order and say that this clause now stands novated by way of this.
lordship, only on
You are
the,
asking.
only on the basis of conduct, your lordship.
No conduct,
Because on the first
conduct
running-
is for the civil code. You ask for interest a day. Are you an MSME?
Yes.
Oh, fantastic. Go there. Do under the MSME Act.
I agree, your lordship,
They're
but
much
at the same
better.
time,
Go there.
the earlier bill, in terms of this section, clause 9.2, the company, the contractor should have first reimbursed us, then get the amount reimbursed from the authority. What they did, what the authority did was first pay the contractor paid us. So they themselves have
No,
not
no,
followed
that-
9.2.
That is different. But these I cannot do it. I cannot change the terms and conditions, neither the arbitrator. But I think you will be well served with 16 and 17 of the MSME Act. Go there, fight it against the contractor, get huge amounts. You are to be paid at 7 into 3, 21% interest. Get it there. Why you are going for an order out here asking only 2 crores 91? This has now exceeded something more than around 6 crores.
Your lordship, I agreed on that particular aspect, but the thing is, this matter has been pending for the past 2 years. And
So,
I have been
therefore, I'm
protected.
finishing it
Your
today.
lordship, I have been protected by a particular interim order wherein the amount which is.
No, that goes for a 6, that order cannot remain. It's a monetary amount, how can there be a question of an interim?
Your lordship,
Money cannot be an interim.
Your Lordship-
Irreparable loss, harm and injury can there be in money?
your lordship, that is what,
Therefore, have you ever heard of in a money suit, any injunction being given? No, no, tell me. I've heard of appointment of a receiver. But have you ever heard of granting an injunction? With due respect to my learned judge who have passed this order, but can you say that? You cannot. Anyways, I'll come at 2 for dismissal.
if I may submit one thing, since on the morning half, your lordship actually observed to approach before the MSME council here, I would have approached the MSME council or for any civil court, had there been a disputed amount of, the amount should have been disputed. They are not disputing that particular fact. In fact, that is admitted also in the affidavit, if I may take your lordship to para 17 of my writ petition, wherein I had stated everything with regards to this payment and how it has been approved also. And there, in reply to para 17 in the counter affidavit, they've admitted that amount
Where is the affidavit filed by them?
by the NHIDC.
No, the respondent.
Private respondent is not filing it.
That is the main problem, no? They have to admit,
In
they are going to reimburse only one when they pay.
Your lordship, that is what they are not in a position to pay because their account has been declared as NPA. If any amount goes to their account, it will be deducted by the bank. That is the problem, your lordship.
Contract has been concluded, arbitration proceeding is going. And my EG has already withdrawn by the. Then.
I am in a fix right now, your lordship, because if I approach
Do you admit to that amount?
We have forwarded the bills direct to the NSID chair, page 59.
Huh?
page 49 of the rate petition, your lordship. And in that regard, they have given undertaking also to pay directly to, because NSIDCL themselves have asked for undertaking. That's why I was on the conduct portion, your lordship. They should not have asked for undertaking. They wanted to bypass this particular 9.2. That's one.
Where is your bill?
At page number, your lordship. That was forwarded, page 63. The authority engineer should approve the bill. The bill which is submitted with the authority engineer.
By?
By the contractor.
How does the contractor submit it to the,
Authority
Is it
engineer.
by some other person?
Authority engineer is the one who certifies the bill for payment. As per the contract agreement, your lordship. Authority engineer page number 65 of annexure 15. So in continuation of page 63, last page, they recommended the bill in light of above statements. This office is recommending the release of net payable amount of against final bill of electrical utility shifting work from so and so to Messrs. Ramki TK JV. That's why on 28/8, when the matter came up before your lordship actually raised a query whether this can be done in terms of the undertaking. And the respondents council, they took time to get that particular approval from the clients as such. So it was again fixed on 11, but it came before the wrong bench. There is no disputed amount, your lordship. They are admitting that particular amount.
Who?
All the respondents, your lordship.
No, then also. I'll help you. Where is your agreement with the respondent?
There is no agreement, there is a work order.
Where?
The work order at page number 40, annexure 3. Next page, page 41 is important payment terms. Clause 5.
Here there is no signature of the AR, but they changed the terms. Clause 5A,
Yes,
they changed the terms.
they change the terms.
But as per clause 9.2, they are not supposed to pay.
That is, I agree, but in the first running bill, first NHIDCL paid to them in terms of just like this. they paid to the contractor, contractor paid.
No. First, the contractor has to pay it to you, then the
Yes.
NHIDCL
That's what
will
9.2
reimburse.
says. That's what 9.2 says. First, the contractor has to pay me and NHIDCL will reimburse. But the first running bill, in terms just like this work order as the term stipulate, the work order term stipulate, the NHIDCL paid to the contractor, contractor paid to me, 8 lakhs.
You were lucky enough.
Your Lordship, that's why they have done so. NHIDCL has done so.
If the NHIDCL says that they are going to pay, I have no problem in passing an order that they are going to pay if they consent it.
Yes.
But if not, there's no direction. What do you say? You are willing to pay?
Instruction
No.
I have, Lordship.
Are
In
you
terms of
willing-
last order, Lordship. In terms of last order, I have the details.
28.8.
Yeah, they say they are not going to pay. First, the direction was to them to pay and thereupon this. So it is actually a dispute between you and him. NHIDCL has been made a party. Why should this court issue a writ?
Your Lordship, under 226, Your Lordship has got wide amplitude of powers in terms of there being no dispute with regards to the amount. There's
How
no-
do you say that?
Because the contractor is not disputing the amount. The NHIDCL has not disputing the amount.
Contractor is not filed any affidavit to that effect, so we will go on the basis of doctrine of non-traverse
Your Lordship,
and become a civil court.
Your Lordship,
No, then tell me,
Your Lordship, if they want to, they can file. If
then
Your
also
Lordship
you have
grants
to
them-
show, let us go as per a suit. We'll say that, okay, he has not filed his written statement. So your prima facie evidence that you have done the work.
Your Lordship, the authority engineer,
No, forget about authority engineer does not come into the picture.
then the
I'm
authority
only
engineer
asking,
certified.
show me the prima facie proof that you have done the work for this amount.
That is what, Your Lordship, the authority engineer in terms of the contract will have to actually approve that bill.
That is a contract between you and him, where authority engineer is not a party.
13 in terms of 9.2 only, 9.2.
Author 9.2 has no relation with you.
Your Lordship, it has because the.
No,
utility-
9.2 categorically mentions that when there is certain obstructions are there,
Yes.
which are relating to utility services, the contractor has to carry out the work, do the work, and as have been verified by the owner of the utility,
Yes.
shall make the payment. After making of the payment, the NHIDCL will pay.
To the satisfaction of the utility.
Now tell me, where is the APDCL's has given the verification that this is the amount?
Yes, Your Lordship, at page number 50. Annexure 9.
Yes. No, this is not the utility.
That is the utility, the
No,
APDCL.
no. Where's the utility? By this, this is by this approval for energizing so and so.
Your
Where is
Lordship,
it?
page-
The approval.
Page 50 and this clause 2, in this connection, it is to state that the EPC contractor of the subject project is responsible for shifting of electrical utilities as per Article 9 of the agreement, for which the EPC contractor has engaged an empaneled EPDCL contractor. The details of the empaneled contractor engaged by the EPC contractor are Goswami Engineering, the petitioner, and one other Dipali Enterprises and DK Construction. In this regard, they were actually asked to, as a supervisor, you are the supervising consultant. Para 4. The APDCL is the supervising consultant and they have to
Mr.
approve.
Mr. Patel, I hope I'm being able to make you understand. Where is APDCL? Is the owner of the authority utility
Yes,
certification that you are entitled to this amount?
that is what. Next page, page 52.
Yes. Where?
This is the letter written to the subdivisional engineer, APDCL, Vishwas Ali.
No, understood,
approving.
where is the certification by them?
Your Lordship, this was actually treated as a certification that the work has been completed.
No,
Now
and
charge
not
the,
the amount, kindly see 9.2.
the amount as such.
Actual cost of such shifting as approved and communicated by the entity owning the utility.
Yes,
Entity owning the utility is APDCL.
APDCL.
Shall be paid by the contractor and reimbursed by the authority of the contractor. So therefore, where is that certificate?
Your Lordship, this itself was actually said to be approval for energizing of that particular.
Where is the approval of this amount?
The amount as such,
Then,
it is certified by the SUP, the
yes, you have done that work, understood.
authority engineer.
But does it mean that what is the amount?
The amount as such, Your Lordship, if I may take. The contractor wrote to the NHIDCL at page 61.
APDCL is certifying, where is it?
APDCL certifying, Your Lordship, the authority engineer has admitted in their own letter certifying that particular fact.
Authority engineer says that the work has been done.
Yes, subject to satisfaction of the APDCL.
But where is APDCL certification?
Lordship, that is not annexed in this writ petition.
Then-
I agree.
What case you have? No case.
Your
The
Lordship, that was
problem which
actually,
arises, Mr. Bora, is this. This is a fight between you and him. You are filing the instant writ petition by involving NHIDCL.
because of,
But your dispute is with him. NHIDCL says that if he pays that amount, we are going to reimburse. As of now also.
Lordship, that is true,
So
but
then,
on the, just as I
and
said,
he is not going to pay.
just as I
He
stated.
says that I have no money. So then what are you going to do? Can this court issue a writ upon him to pay? Or should this court therefore change the terms and conditions and say that NHIDCL then also should pay?
Your Lordship, the conduct, that's why I'm gonna conduct. Your Lordship, the first running account bill, the NHIDCL themselves.
Any conduct, whichever, when things are going good is good. But this is not going good now.
Your Lordship, a sort of a parallel can be drawn with regards to the doctrine of promissory estoppel because their own conduct itself, they themselves deviated from clause 9.2.
Who?
NHIDCL, when they paid the first running bill, they themselves deviated. If they could do then, why not now? Your Lordship?
Mr. Bora, first of all, the deviation is on a running bill. It is more like an advance being paid. But this is nothing to do with 9.2. Tomorrow, yesterday, that day, this person concerned, he must have paid you some 88 lakhs of rupees out here. Then look here, this is the amount we are just disbursing it directly to you because he has asked me. Because it is on a running account. But can you have that running account for finalization of the bill? Finalization is a bill has to be in terms with the contract. We may direct NHIDCL to recover this amount from him. Recover this 88 lakhs from him. Not paid as per terms. No case, that case.
Lordship, the Lordship then may give the liberty to approach the MSME council then, the 16th. Lordship,
MSCB, you can file it against them.
against the contractor.
You can file it, na? And the period I can, when the
section-
amount was likely to be paid,
Way back in 2021, Lordship.
21, na?
21.
Then we remove this 2 years pendency,
Section
and then
14.
it comes within the period of limitation.
Section 14, Your Lordship.
Huh?
Section 14.
Section 14. Then I give you this benefit.
Very well.
So you approach whatever we are, not MSCB, wherever you want,
MSME.
that these 2 years will be excluded. When the matter has been pending till date, be excluded while computing the period of limitation. That is the best way. Because otherwise there will be some problems.
Yes.
Heard Mr. D.K. Bora. D. Bora, the learned counsel appearing on behalf of the petitioner. Mr. And I do one thing. I keep this matter, the interim order, operational for a 15 days from the date of the present judgment. For a period of 15 days, so that you can take whatever you.
Yes.
Don't release it till then.
No.
No, this amount, 2,21,008,249
2 crore 20.
shall be secured and no payment shall be made without the leave. So this amount, don't pay for a period of 15 days unless he obtains, say, some prohibitory injunction. Mr. D. Bora, the learned counsel appearing on behalf of the petitioner. Mr. R.K. Talukdar, who appears on behalf of the respondent numbers 2.
1, 2, 3, and 4, my lord.
How do you appear for one?
Lordship, I can, lordship.
Huh?
I can.
You cannot.
Lordship, there is a notification from the Minister of Transport, lordship.
You can appear for a defense secretary.
Lordship, there is a typographical mistake, Your Lordship. There is a typographical mistake. Defense.
Minister of Transport, lordship.
Huh? You
Respondent number
cannot appear for respondent number
1, lordship.
Yes. Defense Secretary, Your
It's
Lordship.
defense secretary.
Defense, Your Lordship, that word. Number 1 of defense word.
Yes. It should be secretary, my.
Secretary.
Mr. R.K. Talukdar appears for respondent number 2, 3, 4. And you? Appears for the respondent number 6 and 7. None appears for the respondent number 1 and 5. The petitioner herein is aggrieved by the inaction on the part of the respondent authorities, more particularly the respondent numbers 2 to 4, in not releasing the dues to which the petitioner claims to be entitled, in not releasing an amount of rupees 2,21,008,249, which the petitioner claims to be entitled on the basis of the work order dated 27/10/2015. Post. The materials on record show that the petitioner, which is a micro, small and medium enterprise, is an empaneled contractor with the Assam Power Distribution Company Limited. Pustu. The respondent number The respondent number 2, 3, and 4 have granted a contract to the respondent number 6 for the purpose of construction of the national highway number 52, na?
52.
From Biswanath Sariali bypass to Gopur. That is Cheney's kilometer 208,002 km 265,000 in the Sonitpur district of the state of Assam. Pusto. The said contract entered into by and between the respondent number 2, 3, and 4 with the respondent number 5, respondent number 6, contained a clause being clause 9.2. The said clause being relevant is reproduced herein under page 38. The record reveals that the respondent number 6 issued a work order to the petitioner for shifting of HT/LT lines in between Biswanath Sariali to Gopur from KM 20800 to 265.500. In the said work order so issued to the respondent number, to the petitioner by the respondent number 6, the payment terms have been duly mentioned at clause number 5 of the work order dated 27/10/2015. Clause 5 of the said work order being relevant is reproduced herein under page 41. It is further seen that clause 8 of the said work order further stipulated that if any kind of dispute or differences arises during the execution of the work, the same shall be settled reconciled in cordial manner, and the decision of the Assistant General Manager of APDCL, Biswanath Sariali, shall be final and shall be mandatory for both the parties. The record reveals the petitioner claims that in terms with the work order, the petitioner have carried out the work and out of the said amount to which the petitioner is entitled to, an amount of rupees 88 lakhs have already been paid by the petitioner, paid to the petitioner. And the petitioner is further entitled to an amount of rupees 2,21,008,249, 2 crores. 2,21,008,249. And it is on account of non-payment of the same, the present petition has been filed. The respondent number 2 to 4 have duly filed their affidavit in opposition, wherein the stand is that the question of payment of the amount by the said respondents to the petitioner does not arise unless and until the said payment have been made by the respondent number 6, and thereupon only the respondent numbers 2 to 4 shall reimburse the said amount. The respondent number 6, however, have not filed an affidavit in opposition. But a counsel appearing on behalf of the respondent number 6 and 7 submits that the contract between the respondent number 6 and the respondent number 2 to 4 have been foreclosed, and there is an arbitration proceedings ongoing. In the backdrop of the above, the question therefore arises is as to whether this court is required to, should issue a writ in the nature of mandamus, thereby directing the respondent number 6 to pay the said amount to the petitioner. And thereupon claim reimbursement from the respondent number 2 to 4. This court finds it very pertinent at this stage to take note of clause 9.2. Which stipulates that it is the duty of the contractor who shall cause shifting of any utility bracket including electric lines, water pipe and telephone cables to an appropriate location or alignment if such utility or obstruction adversely affects the execution of the work or maintenance of the proper highway in accordance with the agreement. It further stipulates that the actual cost of such shifting, as approved and communicated by the entity owing the utility, shall be paid by the contractor and reimbursed by the authority to the contractor. Therefore, the question arises in the present proceedings as to whether there has been any approval given by the entity owning the utility. The answer is in the negative, taking into account that the owner of the entity, utility, in the present case would be the Assam Power
Distribution Limited. Your Lordship,
Distribution Company Limited. And there is no certificate to that effect produced before this court.
Your Lordship, Annexure 10, page 52. They themselves have stated Goswami Engineering everywhere, the transformer which has been installed by us.
This is
APDCL,
actual cost.
actual process not.
The actual cost of such shifting, that is the word used.
Your Lordship, page 64, the authority engineer at page 64.
Is the authority engineer the so and so?
Your Lordship, they certified, they
Go to
themselves.
the division bench for the remaining year. I have dismissed it right away.
No, Your Lordship,
Enough.
I apologize.
Enough for me. Khile tu. Would be the owner of the entity, the owner of the utility in the present case would be the Assam Power Distribution Company Limited. And there appears to be no certification by the said APDCL in respect to the actual cost of such shifting. Favoring the petitioner. This court further takes note of. No, Mr. Deepora, the learned counsel appearing on behalf of the petitioner, though submits that the authority engineer of the respondent number 2 to 4 have duly stated that the petitioner have carried out the works, and this is further supported by the senior electrical inspector of the APDCL. No, this is not even by the APDCL.
Page 64. Space 64.
64. This is not done by the APDCL.
chief electrical inspector comes under the.
Yeah, this is the government of Assam.
Government
He is
of-
not the owner of the electricity.
They certify for charging the lights. And also page 64, Your Worship, just page.
Taking into account, if therefore it appears that without the certification done by the entity owing the utility, which would be the epidician, the claim of the petitioner that the petitioner is entitled to the said amount of rupees so and so, the 2 crores की वजह से, cannot be directed to the cannot be accepted in the present proceedings. In addition to that, clause 9.2, as quoted above, makes it very clear that it is for the contractor, that is the respondent number 6, to first pay, and thereupon the same would be reimbursed by the respondent number 2 to 4. And admittedly, the respondent number 6 have not paid the said amount. And admittedly, no payment have been made. As it is the very case of the petitioner. It is therefore the opinion of this court that any direction being issued by this court upon the respondent numbers 2 to 4 to make any payment would amount to this court in exercise of Article 2 to 6 of the Constitution rewriting the contract. Which, in the opinion of this court, the powers of judicial review is not. Which, in the opinion of this court, the powers of judicial review should not be exercised. Considering the above, this court therefore does not find any merit in the instant writ petition for which the writ petition stands dismissed. Consider. It is the further opinion of this court that the dispute in question is primarily between the petitioner and the respondent number 6. And a dispute of a private nature between the two parties, between the petitioner and the respondent number 6, is sought to be redressed, sought to be the private dispute between the petitioner and the respondent number 6, and such disputes in absence of proper certification would come within the realm of disputed questions of facts. It is the further opinion of this court that such disputed questions of facts cannot also be adjudicated on the ground that the evidence has to be led And it is in a proper forum wherein evidence can be adjudicated. Such disputes can be adjudicated, can be dealt with. Considering the above, this court therefore is not inclined to entertain the reinstant writ petition in view of disputed questions of facts as well as the observations made herein above. Accordingly, the instant writ petition therefore stands dismissed on the ground of being not entertained. According to the record, this court, however, observes that as this court is not entertaining the instant writ petition on the ground set out here on the grounds and reasons set out here in above. And further, taking into account that the petitioner has been diligently and bona fidely litigating before this court, the period the petitioner would be entitled to the benefit of Section 14 of the Limitation Act 1963 for a period during which the present proceedings have been pending. Accordingly, this court therefore observes that the period from 10/4/2023 till date be excluded while computing the period of limitation in respect to the claim in the circumstance the petitioner approaches the appropriate forum for redressal of its grievances.
Section 18 of the MSME Act, Your Lordship.
What?
If your Lordship gives me
Why
the.
should I write? You are there. I'm not giving the last portion also.
Your Lordship may kindly tell him not to,
Why should I tell?
Your Lordship may at least give
For
that.
disturbing
particular-
during the hearing?
Your Lordship, I'm very
Go
sorry.
into
Your
the
Lordship.
division bench. The division bench may help you. They are more kinder than me.
I'm very sorry, Your Lordship.
Absolutely no. Next.
May it please your lordship. My lord, the petitioner is the lessee. He was settled in a tender process to run the ferry service. My lord, the page, it starts at page 41. For a period from 24 to 26. And my lord, ultimately a lease agreement was entered into by the ferry for a ferry service. The lease at page 47. It was from 24 to 26. My lord, before I proceed, my lord, on the very first day, there was an interim order not to open ultimately the tender process because the conditions in this, under the rules is that, my lord, we are not entitled to any compensation if there is in violation of terms. We cannot get any compensation, neither the security amount that the rules provide. And moreover, my lord, we are debarred from participating for next 2 years if we are terminated for next 2 years in any tender process with the ferry. So that is kind of a blacklisting. And my lord, no compensation, nothing of that sort. That is the rules what they provide under the 68 rules of ferry service. I've got the rules, my lord. I can place that rules.
But you have willingly accepted them.
My lord, I have willingly accepted that, my lord. I have come before this court only because, my lord, your lordship will find the definition of lease. I have never subletted them. The reason, first of all, they terminated me without any show cause. I approached this court said, let them continue because you have not given them any show cause.
No, this is not the honorable court
Please,
order.
please, my lord, the first termination order your lordship will find.
No, anyways, the order which has been passed by Justice Medhi
My lord,
shows
that-
that there is a termination was preceded by a show cause.
My lord.
The
My lord, so
termination
what-
order dated 19/5/2025 is preceded by a show cause.
Show cause, my lord. And that show cause, we have replied to that. On that reply, they have, my lord, there is no discussion about whatever point we have raised, no hearing given to us. And my lord, they are taking a so much strict punitive action against me, my lord, that no compensation, no security amount, blacklisting. Was it not necessary, my lord, to give me and the rule provide your lordship? may
Where
just-
the show cause?
My lord, the show cause after the High Court's order, my lord, your lordship may just look into page 66.
Page?
First of all, page
First,
66,
let us see the show cause.
show cause page 67.
Where is it?
Page 67.
67.
My lord, that is after the High Court's order.
Anyway, the High Court have set aside it on the ground that there was no show cause.
Show cause.
So anyways, now therefore, that I have understood. Now the question is, you have been issued a show cause. Where is the show cause? That is
Page, page 67.
show cause. Enclosed, please find herewith a copy of the authorization letter wherein you have authorized so and so for remand. You are asked to for operation of Sunari Benda on your behalf, but as per rules here, the RIA cannot sublet, encumber or transfer in any other way the lease, ferry lease to him. You are therefore asked to explain why necessary action should not be initiated against you regarding cancellation. So the only is because of you subletting.
My lord.
The clause 15 of the lease says that you cannot sublet.
Clause, rule 7, clause 15, my lord, clause 15.
Clause 15 says that you
Page
cannot sublet.
48, page 48.
Page 48.
And the rule 7, under the rules.
We'll see rules later on. Clause 15 says so.
The lessee shall not sublet the farm.
Where?
Page 48, clause
That
15.
one, the lessee shall also not sublet the ferry.
That much. But we have denied because the lessee, we say that we have never subletted. We have only given somebody to look after, my lord. And the lessee
What do you mean by that?
my lord,
Look
because
after?
the lessee definition says, my lord, means a person to whom a ferry is settled shall be deemed to include any agent, boatman or servant employed by the lessee. It is their rules and the lessee definition gives that such.
Where?
My lord, this is the rules I'm giving, my lord, this is the rules, my lord, I'm giving. The definition of lease, lessee. Your lordship will look into this. Definition of lessee. Second page, my lord, rule 2A.
2A, lessee shall mean a person to whom a ferry is settled and shall be deemed to include any agent, boatman, servant employed by the lessee.
My lord, we have employed somebody and they have given an affidavit. We have said, we have never handed over the exclusive position to anybody.
You have?
I have never
have
handed
employed-
over
No,
exclusive,
no, wait. You have employed them.
employed them. My lord.
Where is it?
My lord, even my lord, the later they have
Where is
added,
your affidavit?
my lord,
Where have you employed?
my lord, first of all, page 69. That is what they have stated. Page 69,
Motiur Rahman.
my lord, this is
Who is
me.
Motiur Rahman?
I am the Motiur Rahman, my lord.
You
Lessee.
have given an affidavit.
My lord, this is my affidavit. And my lord,
Authorization letter is of 1st of November 2024 at Gwalpara. I am Motiur Rahman, so and so, of Iman. But I am facing communication troubles to take care of the ferry ghat as because I hereby authorize so and so to take care and run the ferry smoothly to so and so during my lease period from so and do hereby authorize. Is this real communication?
my lord, this is, and my show cause is their next, and their affidavit, their
I'm asking
affidavit,
you, this is the document.
this is the document, my lord.
Are you
And
denying or not?
my lord, this is, I cannot deny, this is my document, my lord.
Well,
My lord,
enough.
and my lord, your lordship will find at page 76, they have filed an affidavit saying that they are laborers. The person, that two persons who they allege, that they have given an affidavit that we are the laborers.
No. Let them say this, the reading of this document say that I am being a resident of so and so, having communication troubles to take care of the ferry service.
My lord,
That is because I hereby authorize so and so to take care and run the ferry smoothly during my lease period with effect and do hereby
My lord.
execute the authorization letter in presence of the following witnesses.
my lord, does it mean, my lord, that I have subletted, given an exclusive possession?
It is not a question of subletted, you have handed it over.
My lord,
This is more bad.
my lord, I have not.
Because
handed
of
over-
you people, the people
My-
are dying.
My lord, one thing your lordship will find, my lord, here,
Okay, now this is proved. Now come to the disproportionate.
my lord, the penalties are at 26. My lord, your lordship will find pay penalties, page rule 26 in the rules, that is the lease agreement. 26, the lessee is liable to following penalties. And rule page 50 of my writ petition, lease agreement.
Now, in the rules, it is given.
Rule 36, your lordship will find no compensations. Rule 36.
Compensation for what?
My lord, if it is
Violates or fails to perform any of the covenants contained in the year, he shall, in addition to any other liability, be liable to have its lease cancelled by the secretary to the government in transport ban, and in that event shall not be entitled to any compensation or to the refund of any portion of the ferry, advance or security of anywhere. Is liable to cancellation under preceding chapter in lieu of cancellation allows the lease lessee the option of retaining it wherever a lease is liable to be under the preceding sub-rule. The secretary of in lieu of the transport department may, in lieu of cancelling the lease, allow the lessee the option of retaining it, subject to payment
Payment
to the
of-
government a sum of rupees to for each breach
Breach.
or default
Malad.
as he deems fit. So you want that you should be, will come under 36(2).
2. That much, my lord. Is it not, my lord, as your lordship said, disproportionate? And my lord, my
I'm
lord,
not saying disproportionate, I'm
Asking,
asking you
understand.
to argue on disproportionate.
my lord, and another thing, my lord, your lordship will find, though, my lord, here, and on the day when that interim order was passed, my friend has suggested before the court first suggested me, why don't you participate in the next tender process that have been issued? My lord, then my friend submitted that I cannot participate in the next 2 years.
Is it a verbal submission? It is not recorded.
My lord, I can place it in the TV also, man. It is still,
submission.
a verbal submission is there that I cannot participate in the next 2 tender process. That amounts to blacklisting, my lord. And my lord, if lordship permits me, my lord, this, my lord, what I got from the recent judgment of my lord Supreme Court in case of this, my lord, Techno Prints versus Chhattisgarh textbook. If your lordship just look in para 33 and 34, and another judgment of my lord page 24 in this is para 26. No? 25 to 25 to these are subject to all my correction, my lord, pay this 25 judgment, my lord, that was as regards, my lord, textbook corporation, some loss submitted.
Where is it? You have been only picking order.
Mhm.
Although follows examination of question is down to the examination.
The impugn order that has come, my lord, that is at page 79.
Okay, now why do you say that you have been blacklisted?
Well, because my friend's submission on the day of interim order was passed, that when the court asked me, why don't you participate in the tender process? Then my friend submitted before the court, the next 2 years you will not be entitled to participate.
Lord, if he wants to participate, he may participate.
Then-
If we will rejected his case, that will be a different matter. And that I have submitted before my lord, that it is as per the tender condition, he may not be participated for last 2-3 years because he's violated the tender condition. In fact, what is the prayer in the
Now, whether it
petition?
is mentioned anywhere,
No, my lord.
the tender condition that
There's
he
some,
cannot participate.
some other cases I have seen, my lord.
Ah.
Some conditions are there. That's why I have submitted verbally. He may participate and
No.
the department will reject it.
My lord,
I'm
how
not saying that he
tender-
should not participate. I have only
Because
assessed
the
my
interim
lord.
order
to
was
say.
passed only on that count. That my friend submitted that he will not be allowed to participate. Now, my lord, the tender
So,
process has
on
gone,
the
it's over,
submission, he did not participate, lordship.
and the
Lordship-
tender process has proceeded. Now only the final thing has come out. How could I participate now, man? And my lord, your lordship can
But
find
is it recorded?
No, lordship.
that your lordship, the interim order, your lordship will find. Interim order.
What is your stage of the tender process now?
Lordship is completed, my lord. Only this matter is pending before this honorable court.
No
Because on,
restriction for going ahead with the new tender process. However, all actions taken would be subject to the outcome of the litigation. That we go any final or the allotment, yeah. So what is the stage of the tender?
It's over.
it's completed, my lord. Only to, finalization is pending because of the pendency of the repetition. That's why on last occasion, instruction came to praying before this honorable court to go for the tender, to allow us to go for the finalization of tender, but lordship wish to dispose of the whole matter, so I have filed the affidavit. On last occasion, this was the. Only, lordship, one thing, what is the prayer in the writ petition, my lord, may kindly have a look. Page 32. Lordship, what I have submitted verbally, it is written in the tender agreement, my lord.
Where?
The page 37, clause 16?
Page 37,
Yes, my lord.
clause 16. On scrutiny and finalization, where withdrawal of tender by any participation will take not only forfeiture of them, but also participation will be barred from future condition. But this is a different.
Well, yes, this is different. I cannot, I'm not saying that he cannot participate. I said this is the clause, this is a different issue. He can participate, but he did not participate. I have submitted verbally before this honorable court. He may be diverted from that because this is also violation of conditions. But he can participate that if we are rejecting his case on my verbal submission, it's a different issue, my lord. This may not be a case, lordship. Page 32, lordship may kindly have a look the prayer before this honorable court.
So the question is, how can we settle the dispute? The question of he losing, you terminate, but you also cannot participate. You are not in good health. That is
My
your own stand.
No, my lord, participation because.
No, Mr. Roy Chaudhary, why on earth, if you are not denying that contents of that document, wherein you say that because of my health conditions, I am not in a position to run it, so I am giving it. to
My lord, I have
somebody
given a
else.
statement in oath of, because the
It
repetition.
doesn't happen.
My-
You have to, why should this court
This,
at all take into consideration that submission, taking into account that you must have given up all
my
these
lord,
things.
if
You are not
it is
good
in
health.
violation, if it's in
Absolutely.
violation of the
When-
terms,
No, when the tender condition categorically mentions that you cannot sublet, you cannot sublet.
Yes.
And this is a case of you are not only subletting, you are giving it. And because of you, these accidents happen.
Yes, yes,
There is a
My lord.
PL order also.
yes.
my lord, why cannot they take the 36(2)? Why not
Why? They
30
should not. In fact, they should amend these clauses and put it, try to put more stringent punishments
Yes, my
on
lord.
these type of people who sublet it. Because of you, in another matter that day,
Yesterday.
I interfered with and asked
Yes.
them to go ahead with a fresh show cause notice. But the fact is, because of these type of things where you take the year and thereupon give it to somebody else, and then they use it in some manner, and this for that result, people lose their lives.
My lord, in the other way around, my lord, there are person behind us, another person who wants to take the ferry, They are in hands in gloves with the department and they want to throw us out. That is why the issue is coming up.
Why they should not throw you out when you are not in a position to run? This is your categorical statement in that document.
My lord,
This, unless you, therefore I ask you, do you deny this document? You are not concerned with anything else. Here, what do you say? I am being resident at Borpeta, facing communication troubles to take care of the ferry ghat,
my,
as because of which I hereby authorize till when? During my entire period, and you
Well,
issue this on 1st of October 2024. When do you get the contract?
my lord, my contract was given to me,
On 1st of October.
my lord, first of,
Huh?
for the first.
This is not. I'm not going to. 1st of October, you are given the contract.
Because my lord, the contract was given prior to that, but ultimately it was handed over to me on
on
first of.
1st of October. And this is how you do it.
My lord, here
I am
was,
not going to. No, nothing doing. This type of action is not. This is a case of dismissal with cost. 50,000 is minimum.
my lord, how, my lord, your
No,
lordship will find.
No case. Because of this document, the moment on 1st of October, it was handed over to you. On that very day, you hand over to somebody else.
My lord,
And
how could I appoint a person if I not hand over to something to do something to look into, my lord? If the lessee
No,
definition is
no,
taken
no,
into.
no. Kindly see the language. During my entire lease period,
Mal.
with effect from 2/10/2000, do hereby execute this so and so. The entire lease period you have given.
My lord, entire lease period, I have appoint somebody, if he is an agent, then he is a lessee.
No,
And agent is also, my lord, agent.
he
can
is
be
not your
subletted.
agent.
My lord, I have given, my lord, I have never said I am sublet. He is an agent of mine. And he is saying, my lord, he is a boatman, a servant, and person employed, and even an agent. My lord, this is the definition. And never I have said I have subletted. The definition says he is an agent, boatman, or servant employed by the lessee. He is also a lessee, my lord. How could the, my lord, they come to a finding that on this letter it is sublet?
Okay, what is the experience of your agents?
My lord,
What are the experience of your two agents?
my lord, agents, my lord, what they have fit me.
Okay, what is the experience of those two agents?
My lord, they are helping me in getting
No,
those.
no, because you cannot come. They cannot help you. Because this is your own statement out here.
My lord.
Because you cannot go there. Because of that, you have
No, no, I said not, communication trouble.
Mr. Roy Chaudhary, don't switch your words.
What
Page
is
69,
communication trouble?
page 69 is very clear.
I am a
You say
resident of Borpeta
facing-
facing communication trouble.
to
take care of the
no,
ferry.
why you are giving for the entire period?
Well, I have employed somebody as an agent.
You are not employed somebody as an agent.
Or my lord, because
You are, I hereby authorize. It is an authorization.
but a nomenclature of a word doesn't mean that it is sublet. Then my lord, I could have insisted on I am subletting that to give an exclusive
Okay,
position.
Now tell me, what is the qualification of your agents?
My lord, what they have stated in their affidavit, your lordship will
I'm
find.
not concerned with their affidavit. What is your qualification of your agents?
My lord, they have virtually, my lord, what they say that they are aged about 48 years, and my lord, another is, my lord, I have given their affidavit, another is 35 years. They are working as a wage basis on a laborer bill, as a laborer as wage basis. They have what they have stated, and these things were
they
never
are
considered.
working on wage basis.
Wage basis.
And you are believing on this document.
My lord, these documents were placed before that.
No, I'm asking you, you are believing those two documents, you are placing.
I have placed before
emphasis
the
on that.
authority. I have placed before the authority.
Okay.
Authority has not neither asked me for give me a personal hearing, neither the
No,
interrogative.
hearing not necessary. We'll take care of this, how these people, they are profession of labor.
Labor.
And they have been done out there. This is being done on 9/5.
9/5. Before the, my lord, this order came out on 17/5. And the show cause reply was 13/5. It was received on 13/5.
Chalo. We asked the personal appearance of these two persons.
My lord, your lordship will ask them to come with the.
Ask them and know whether they know this English?
My lord.
Because it has not been mentioned that they know this English.
My lord, if your lordship permits me to make a small submission, my lord, I understand what is my situation over here now. My lord, if your lordship just look into that judgment, my lord, here virtually I have violated terms and conditions.
Judgments are for the Supreme Court to look into it and the Supreme Court will pass. You go to the Supreme Court against
My
this
lord,
judgment.
For every,
I'm not going to look into those judgments. Here is a case, it will be dismissed with cost of something like 50,000 for making false statements and false
my
affidavits.
lord, let this
And
person,
thereby, no, I'm putting it that it is a false affidavit being filed. Initiating 344 proceedings or whatever BNSS proceedings against these two persons. And for filing of FIR by the registrar against these two persons. And thereupon you file an appeal before the division bench, get it set aside, that do whatever you feel like. But this
subject
is
to-
the order you are going, no, absolutely. This is a case on this. And you are making a statement on this on oath. Where is that statement? Because this is a case and therefore asking them to file an affidavit against it. You had earlier stuff.
my lord,
Did you have earlier?
earlier stuff is there, earlier stuff, almost stuff, you know. Some stuff,
Earlier stuff was there?
stuff was there. That instruction, my lord, I don't
No,
know.
obviously you cannot say no because today the matter has been taken up for admission. It at page 29, you have mentioned that you have handed over these things to these two persons
My
because you
lord,
had no stuff.
Authorized, the word is authorized.
You have handed over. Page 29. The authority also stated that the ferry service of the petitioner was only handed over to so and so as there was no stuff. So that means you had stuff.
My lord,
Put the names of the stuff and give on file an affidavit.
my lord.
We are going to vacate this interim order, that is done. You go ahead,
Lordship.
go ahead with it.
My lord.
And keeping it as part of.
My lord, only thing, my lord, if ultimately, if I don't get
That will be
compensation,
gone.
but
We
I
will
don't get
investigate
compensation,
it.
I am
No, mister.
blacklisted.
No, interim order stands vacated. Interim order stands vacated, absolutely.
Then, my lord, at least one thing your lordship will consider,
No,
that, my lord, let them proceed. Why I'm not saying, my lord, if I am in this position, my lord, let them proceed. Only thing, my lord, if ultimately it is found, my lord, this is disproportionate and ultimately found, they have to indemnify them also.
Huh?
But both the ways,
They are-
they have to indemnify that if it is found that it was not a sublet. They have also have to indemnify because, my lord,
holding it is a sublet means you have done it in contrary violation of the and as well as in endangering the people. So that is I'm only holding it
Because there
right
was-
now.
because, my lord,
But
there-
I'm keeping the matter. Therefore, I'm not dismissing it. For the purpose of investigating purpose, I'm keeping all this other aspect. You go ahead
My lord.
with this and then all your contentions are rejected only for finding out how far these two people are involved and how can it be done so. So therefore, I'm asking them to make an inquiry and investigate in respect to all other ferries where it is being done,
Yes.
including this.
My lord. Lordship.
My lord, another aspect of the matter, whether, my lord, while discussing this, the authority, when there was a direction to show cause and reply, and when those points were raised before the authority, was it not necessary before taking a strict punitive action against me?
What is the strict?
My lord, because,
Cancel.
my lord, cancel along with that, my lord, if my friends suggests that I can participate in the next tender process, I withdraw my contention, my lord. If he,
You cannot participate
well,
because you are not in good health. You see,
no, my lord, I have, because
you cannot participate there. So therefore, that consideration is taken out.
because, my lord, the only word is that I cannot communicate.
That is not on oath.
My lord,
Nothing is-
that affidavit which your lordship has found regarding the appointment of those two person, affidavit filed by the lessee, my lord, that I could not communicate, that is why. As
No,
because,
you cannot. Therefore, if you cannot communicate on that very day on which it has been handed over, you on that very day don't hand over to somebody else. And that too for the entire lease period. These people, persons like you should be blacklisted. If not, it has not been done, it should have been done. So we dismiss it with a cost of 50,000.
My lord, your lordship will not do that, my lord.
No, 50,000. This type of, because you have gained a lot, you must have rented it out to those persons and taken a huge amount of money from them. So you need to pay that. This type of cases cannot be allowed. With cost. Now,
At least, my lord, your lordship will consider, let them proceed with that. Ultimately, if it is found, my lord, that will be subject to outcome of the writ petition.
I am dismissing a petition with cost of 50,000 and now you are saying something
My
else.
lord, your lordship, because let them, because
Nothing remains. The cost of 50,000 is being imposed with you and then now you are asking this. Division bench may help you out.
my lord, I will not going for division bench, my lord.
Mr. Counsel, I am not going, this type of litigation should not be encouraged at all. We are concerned with the area of the human. of
No, my
people.
lord, nothing has happened
And
to
because-
anybody.
No, absolutely. Because of people like you, this has happened. These people who do not know, these people don't have an experience out there, you just let it out for money. You see, you are bound by the terms of the lease.
My lord,
The
my lord, I
lease-
agree.
The lease contains various requirements to be carried out,
My lord,
which includes even that you cannot overload.
my lord, I admit.
Now, these persons are not bound. Those
Well,
persons are not bound.
Because I am
If
bound,
something happens, you will be culpable not only by this.
culpable homicide.
You
That's-
are also you will be also have a problem with a culpable negligence.
That is also.
But those two persons won't. You have to take care of that aspect of the matter. You're endangering the people.
Then, my lord, your lordship will consider, I will have done my part, my lord. But only thing is this, my lord, I have to,
50,000.
my lord, your lordship may not impose the cost because he is already suffering, my lord, because he is not been.
No, this
But-
type of litigation has to go with a cost.
My lord, your
And it
lordship,
should be
but at least
written
your
out
lordship,
out there and should be put also in a headline also that this type of litigations invite cost of 50,000.
my lord, your lordship may not impose a cost, my lord.
Okay, 35,000 upon him.
Because this person is already
35,000
suffering, my lord.
upon him and 15,000 upon you.
My lord, me, my lord, why should I, my lord, my lord, I have not done anything.
You share it with him.
My lord, why, my lord, my lord,
Share
I have
it.
gained nothing out of it, my lord.
Then you have so compassion for him, you share it.
But I have to do my part, my lord. It is
Okay.
my duty to
So
assist the court. My lord.
15,000 upon you and 30,000.
My lord, that will be, my lord, stricture on me, my lord.
No, it's not a stricture. I'm saying that.
My lord,
On account of being compassionate towards the petitioner, 15,000 is being to be dispersed.
my lord, your lordship may not
And that
impose the.
15,000 immediately goes to those, to the.
My lord, your lordship may not do that. Only thing is this, my lord, your lordship, if your lordship finds that this is really for public interest, it is bad in law, my lord, then your lordship may dismiss it, my lord, I have nothing to say. My lord, only thing is that, my lord, your lordship may not impose the cost. My lord, that much pay I am missing, my lord.
No.
For public interest, my lord, your lordship may look into it
No.
because,
No, you see, these type of things, what is there now, what you have done? I would have, if you have not mentioned about, therefore first my question is, do you own this page 60?
I cannot deny that. My lord.
And if you have owned this page 69, then you are putting people at risk.
My lord, because it is.
Very, very serious.
My lord, maybe it is, he has handed over to somebody. I don't know, my lord, because the language sublet was not written there. my
It
lord.
is not required for a subletting business because, but the fact remains out here that this type of things cannot happen. Okay, let me come back and pass the thought. After this, I'll take your first matter before passing this order. Hey, इतना से मैं इतु के दूसरा order दिसिलो, तीनटा site order. Your case is of site visit site.
Yes.
Okay. He इतना से Kane Chaudhary से दूसरा order है. Just relax.
I got from one of the person, my lord, that he has that certificate was issued, my lord. And he owns a boat of the my lord there.
He owns a boat also.
My lord, that my friend has given me this certificate.
You have made your case more worse.
My lord, the fact we give.
He's not the owner of the boat.
May not be, just now I've got the paper, I've not gone through, just
He's not the owner of the boat. He is a
mechanic
person who plies the boat.
applies, maybe, but he's little bit experienced in that mechanical operator and other stuff.
Obviously, now he cannot ply. This person, Sanwar Hussain. When was this so-called notice issued? Six, 5/2025.
Well,
Because the owner of this SDB Zakaria is one Morfuzuddin Jodhar. And in that, he is appointed as the Sanwar Hussain is the
operation.
this is a different person, na?
Sanwar Malata.
Here the name is Sanwar Hussain,
Mal.
and here the person who has been given is Sanwar Hussain. And the person who has filed the affidavit also Sanwar Hussain. How do you say that he is the same person? See the
Just now, the documents have been seen. Yeah, it is Hossein written. It is Hossein, H-O-A-C-N. H-O-A-C-N, there it is H-U-S-S-I-N.
But he signs his signature,
Son of,
signature as Sanwar Hussain.
here it is Rahman Ali and it is Rukman Ali. This is also Rukman Ali. And this is, affidavit is Rahman Ali. Those are different, I think, my lord. But just now I've got the document.
No, but his signature at page 78 is Sanwar Hussain.
Sanwar Hussain. Hussain.
He
Hussain.
puts it here, but he doesn't know his father's name.
No. Others is Rukman Ali. Here it is late Rahman Ali. Your lordship may dismiss it because I find there is some, your lordship may dismiss it, my lord, because this should not, at least your lordship has said that it should not proceed that way. If he has done it, but my lord, only thing is that, my lord, whether that seriousness is there to your lordship will consider that much only.
Madam, who was running this particular vessel at the time when the SOCOS notice was issued?
When the SOCOS was issued, Lordship, the authorized person, my lord. He has authorized that person. We have made inquiry also.
Let us see his reply, what was given.
Page 70.
Lordship. Page 107 of my affidavit, my lord. Lordship.
So you have deposited only 4,27,000 till now. That is for the first quarter.
Thereafter.
110 to 3112. But the lease was not extended beyond 31/3/2025. Then why the cancellation?
Lordship is lease period up to 2 years, my lord, till 31/3/26. Period is for 2 years.
It was given.
Lordship.
Where is that?
The settlement order, my lord, it's page 41, if I'm not wrong. Page 41, yes, my lord. They have type of, my lord. 41, my lord. Lordship, may I read, my lord? Lordship had got it, my lord. It's from 2024 to 2026.
So you paid 50%, 4,27,000. What is your basis of paying that? Because the total is 7,07,786 per year.
Total is, my lord, your lordship will find. Page 46, your lordship will find.
No. For 17 lakhs, 7,786
My lord,
per year.
per year.
So therefore it comes to 4,27,000. No, in the typographical it is wrong.
Yes, they have written 7 left.
It should be 70.
17.
The money that I have deposited at page 52.
Can we come to page 50?
My lord,
If the lessee violates or fails to.
my lord, the word not is,
Evidence herein contained.
the not is not there, my lord. The word not is not, typographical mistake. In the event shall not be entitled, it should be shall not be entitled, but it is written shall be entitled. Rule provides, Rule 36, it should be shall not be entitled. But it is written as shall be entitled. This is wrong, my lord. The rule provides that I have placed before your lordship. Rule 36
No, but this is the agreement, na?
agreement, my lord. They say that, but it cannot go beyond the rules, my lord, the agreement. Here say they will, I will be entitled to compensation. Let me see that.
How many 4,27,000?
Well, like up to, my lord, 31st 12/2024.
Why there are two amounts? Page
One is KISS
53 and
money.
54.
One is KISS money, one is security.
Security is which one?
My lord, the next one, 4,27,000. One is security, I had, another is KISS money.
But you are entitled to back the security amount.
My lord, but, your,
As per the agreement, lordship, nothing is there. Madam, I observe, they will look into it.
Security amount, because you see, this is the agreement one has signed.
Yes, lordship.
Shall be entitled to any compensation or refund of any portion of the amount advance advance of security.
but the-
Security.
it rules to the vehicles. Even, my lord, the agreement they have annexed in their affidavit also shall be entitled to, but,
This
36
was the agreement, lordship.
36 says
Shall be entitled to the security because 3 months he has worked.
Work.
And thereafter you have not allowed him to work. You have not taken from in January. And therefore, why I was looking into the month of January or reading the pleadings is because the affidavits filed by these two persons
Lordship.
are only they work from the month of October to January. You see the affidavits. Now, tell me one thing, if you are employing a boatman, agent,
Lordship.
are you not required to intimate the officials who are your proof?
The lessee is responsible for all this, but he will have to.
No, understood.
Lordship.
He's required to intimate.
Yes, yes, my lord. Yes,
Where is it?
he did not.
Where is it?
in the rules.
Yes, the rules. Yes, this is missing, my lord, because it's 1968 rules is still following. We are not
Understood, but
amending,
when you are employing some crew,
my lord.
where is the intimation that you have to intimate who are there? Because the rule says the crew, its lease shall be a person to whom a ferry is settled and shall be deemed to include any agent, boatman, or servant employed by the lessee.
Yes, my lord.
Although I don't agree that they are your servants, but the question is, who is the crew?
Yes. There is nothing because they are following the format of 1968, my lord. Need to amend the rules actually.
Because Rule 7 says,
My lord.
the lessee shall not sublet, encumber, or transfer in any other way the ferry lease to him.
Yes, my lord.
That word is too wide enough.
My lord. The so cause notice also, lordship, we have reflected clause 7 of the rule.
So therefore, or transfer in any other way. So this, what they have done will come within the ambit of transfer.
Lordship,
It is not only lease,
lordship,
sublet.
sublet.
Because the rules say that not only sublet, but his
Any-
reply is mostly that it cannot be registered and all these things are there.
Lordship,
But the question of registration does not arise,
Yes.
taking into account that this is a movable property.
I understand.
lordship.
Therefore, the question of all these things which have been mentioned in the so-called reply has no significance. But the fact is,
Yeah.
where is the mention of, how do you mention about the crew? And what is the order being passed by the division bench?
Yes, lordship, I have.
That is an important thing. That
So motor PI lordship, 2008.
because that one thing one needs to look into it, because
Observations are, my lord, para 10 onwards. Para 10. To inform the passenger boarding board visitor.
what is this 2018 Act? Means disaster management.
Regulatory Authority Act, Inland Water Regulatory Authority Act. my lord.
Developed a mechanism for checking compatibility of the safety jackets and then necessary fire measures, so and so, so and so. To ensure safety of passengers and crew on the boat and so shall make the
Lordship, these PLS filed after the Oslakanta incident, my lord, the ferry service for them.
Where is that Act 2018?
I have soft copies, lordship. Lordship, may I go out to? And then need to confirm.
It may give some
Yes, sir.
indication somewhere about the crew. Assam Inland Water moved particularly to regulate the activities of inland water transport operation in Assam. Vessel will be resurveyed, new registration certificate, inland special training. Camps of crew members will be organized and certificates will be issued after competency assessment. Now, if that is the objective behind the Assam Inland Water Regulatory Authority,
To regulate the safety norms of the. boat.
yes, which means special training camps of crew members will be organized and
Yes.
certificates will be issued after competency assessment.
Yes.
Now, Mr. Rochaudhary, if you look into that particular document which your colleague had placed,
Well,
the first document, this person is being authorized,
my lord,
is being given a certificate.
my lord, mechanical deckhand as a deckhand operator.
So these rules came in 2018. At that point of time, this person did not have this certificate.
No. It was issued to him on, my lord, 24/1/25.
24/1/2025. So therefore, he could not have been a crew member.
Not a.
Anyway, you got the copy of that order?
Lordship, I'm sending.
Some Indian water.
Lordship, the boatman should be certificate given by the IWT only.
That is that certificate. That certificate is only valid from 24/1/2025.
Yes.
And more particularly in respect to a vehicle. The vehicle name is also there.
Yes.
STD Zakaria.
Exactly.
And the owner of that Zakaria, that is one Mofuzin something.
May I
It is certificate, certificate, I told her. It is certificate.
But the name is different, as Lordship have rightly pointed out.
It's okay. You, I also know, you also know, and Mr. Roy Chaudhary also know that affidavit has been prepared by them and asked them to sign it. We know. Not go, I don't go into those things much. But the thing is, there is a requirement of putting, if we can put this and close this chapter for all, that whenever you are appointing a crew, you have to intimate the name of the crew, because the crew has also has certain rights.
My lord.
If you see, the crew has also the certain rights as regards guideline for boat safety insured anyone from time to time to ensure safety of passengers and crew on the boat and other riverine vessels. The state government shall make concerned officer responsible so that steps which are undertaken for the safety of air and crew are adhered to completely. So therefore, in each vessel,
My
and more particularly on lease, or even otherwise also in view of this act,
lords.
may be a requirement that these crew members are duly intimated to you, so that you have a record who are there. In other places, mostly they have it,
Lords.
and outside they have it, because then whenever a particular boat is being lost,
Lord.
they know who are the crew members. Something happens out there.
I think the section officer of the particular ghat is under the inspection of.
No, therefore, there are strict directions
Yes,
being also
Lord.
given, who in turn shall be responsible to prepare a weekly report and submit once a month to the director as regards compliance to the provision of 2018 Act and the guidelines issued from time to time. Constitution of the Inland Water Authority to promote the development of swans. Cargo.
Section 21(3).
Now you see, the master has been defined in section 1 Romans 15. Now this particular person from that certificate, you see, he has been made as master,
He has been made a.
master helmsman on the left hand side.
Yes, Lordship.
Master
Name of
helmsman.
master.
Name of the master, Hillsman.
Therefore, master has been defined includes any person except a pilot or a harbor master having command or charge of the vessel. Operator means and includes any person or entity who operates, controls, or supervises any vessel, port, so and so, or any independent owner means in relation to the vessel, the person to whom the vessel or sharing in the vessel belongs, passenger, pollutants, Port, safety. All accounts and receipts of the year.
In fact, Lordship, in the NIT condition, one thing is there, my lord. NIT conditions, base 38, His Lordship kindly have
You're
that.
referring to which clause here?
21 surplus 3,
What does it say?
base
The
38.
result of audit.
Lordship, not the act, the NIT condition. It was annexed in the writ petition itself. Page 38, my lord.
Vessels so operated must
21
have
surplus
proper
3.
certificate of registration, certificate
The
of service.
vessels operated must have proper certification of registration, certificate of survey, as well as proper certificate permits of the crew. So therefore, permits of the crew means this has to be the lessee must operate the existing vessels in the ferry route so and so. Least mandatorily to make all arrangements such as fuel, crew, and other maintenance of AR. The mentioned arrangement will be so and so of the lessee under the supervision of the will be owners of the lessee under the supervision. So the permits of the crew are there. Is the responsibility of the lessee. Meaning thereby, if there are permits of the crew are there is the responsibility, the information that their crew members are also information of the lessee.
Because the word permits of the crew is there. Permits of the cruise.
Permits
So
of
the
cruise
crew
means
member
the
has to
certificate.
be, who are the crew member has to be duly intimated.
Yes, my lord.
To whom?
To whom the IW officials which are engaged in that program, the section officers are there, my
Now,
lord.
along with this, if we read the PIL sumoto,
My lord.
it has to be informed to that person who shall at each ferry center of Assam,
Right.
who in turn shall be responsible to prepare a weekly report and submit the same once a month to the director of so and so as so and so. So this is the officer who will be appointed. Who is appointed here in terms with 10 Roman 4
Lordship, we have section officers, my lord.
section officers?
Lordship. In fact, Lordship, in my affidavit, my lord, we have done inquiry, page 107, my lord, on 31/12/2024.
You don't follow all these things. I've been on these vessels earlier. Even as judge also, there is no safety briefing by two passengers. चलो जी। এইখন হলে আগৰ petitioner ৰাখি দিম। Let me look into it. Make it CAV
Lord.
and have a look at it because of the fact that give the judgment before vacation.
My lord.
Let me have a look at it, what is there. Means, can we bring this necessity of intimation of all the crew members? And this would have some relevance out there. Your claim is dismissed, see, but I think if I can give you back the 4,27,000 as the required security.
The security.
That will be enough.
Lordship, may kindly have a
That will
look,
be-
page
that will be
107.
enough for me.
Lordship, page 107, my lord, may kindly have a look in my affidavit. As enquiry is conducted before issuing the so-called notice and cancellation of all these. What? The enquiry was conducted by the executive engineer, Lordship.
What is it in there?
This inquiry was prior to the termination letter. Termination letter was
No, the fact that these people were running is not in doubt, and in fact,
Yes, my
we
lord.
don't require anything more, taking into
My lord.
account his statement out here. I would have understood that, okay, for a period he is being given.
Yes.
First day on which he gets the possession, he gives this.
110/2024.
You see, absolutely. Well, because we are more concerned about the safety.
My
and
lord,
our
lordship.
requirements of that. Why
Lord.
don't we speak on this? as
My lord. As
well?
per
People's,
DPW.
this is a question of people's safety is
Yes, ma'am.
paramount. People dying out there. And I think, taking into account that you have only cancelled it,
Lordship.
and in view of the clause which is there, it did not include shall not. You should return that 427.
Yes, that agreement, Lordship, I understand that part, my lord, because they have,
Remaining goes
Yeah.
whatever may be.
My lord.
Cancellation and you go ahead.
my lord,
Help us the order recording.
lordship. Have you, can you have
Or-
PAB, my lord?
TV.
Obliged.
And here DPW.
It's production this.
And I've seen the judgment, my lord, passed by your lordship, it is covered. But only thing is that the format makes it very clear. Page 35. Your lordship has mentioned all the, because the format is also, he has visited the site, he has filled up the form. Executive engineer doesn't sign.
When is the last date?
19.
Well, I have some submission to make. I contacted the executive engineer. He has informed that, my lord, though he has submitted this particular format as per the clause 7.1, but nothing has been submitted to authenticate that he has visited the site. In the earlier case, my lord. was, my
Same
lord,
point.
geotech photographs and all, along with the petitioner and his, my lord, representatives, they were there in the particular.
Today is
plot.
16, na?
Yes. Let him visit, my lord, we
You,
don't
you visit today?
Yes.
give
Ask
some
your
kind of
person to
authentication
visit
that
today.
they.
Go there with the geotech photograph.
Yes, madam, this will have to
And
be
then
some.
they will issue you.
That, madam, lordship may dispose it of in that direction, both cases.
We have given in the
But
application, we have given a legal notice.
Additional Advocate General, one thing is very discerning. It's here, it's okay, but yesterday there was another case. Same problem is happening out here because of the side. Either you have to do something with that.
Yes.
Because of that, something is wrong with your officers out here, and that person missed out the bus because of that. He filed it on 4/9. And the petition had all the photographs of geotech, everything was there. Then he complains to the chief engineer doesn't do anything. On 6th, he files the writ petition. But the sad part about that particular counsel, no, about that client petitioner, was that the counsel was not diligent. And he waits till yesterday.
I understand, madam. We-
And
we-
10th, the 10th was the last day.
Yes. So,
So therefore, I said that, okay, I can't do anything to that effect, but I'm asking this executive engineer to give reasons why he did not issue it. And if it is not being issued, then it would come within the ambit of Article 19(1)(g). And it would be a constitutional thought. So we therefore, that is how it is being dealt with.
Here, one that he has filed application send legal notice. Nobody has said that you take a geo photograph. Nothing is there, man. And he has been going to the office, nobody said that you give this and all, and NIT doesn't say so. Page 24 is the NIT.
Enclosed herewith, I want to request you to issue a sidebar in the prescribed format enclosed in.
Prescribed format is at page 35.
Page
35. It doesn't say anything, madam.
name of the work. No, but you have not signed, na?
No, we have signed. We have
Page 35 is not signed.
We have submitted, madam. He doesn't accept it, madam. Then we have sent a legal notice.
Heard, Mr. Mustafa. Both are same contract.
Yes, same contract, but one is as regard package number 58 and the other is 59 and 60. Serial number 58 here in this case.
59 and 60.
59 and 60 in the other.
I am taking up unique. Both are unique.
Yes.
No, unique. Unique is which package?
Serial number 58, man.
58, na?
58. Paka bed button.
Heard, Mr. B.D. Das, the learned senior counsel.
58. 59, 60.
Serial number.
Who appears assisted by Mr. So-and-so, the learned counsel appearing on behalf of the petitioners in the petitioner in both the writ petitions. I have also heard Mr. B. Gogoi, the learned additional advocate general Assam, who is also the standing counsel of the respondent PWD. The petitioners, now taking into account that the issues involved in the batch of in both the writ petitions are similar, and there is an urgency expressed in the matter, the both the writ petitions,
One handwritten instruction they have furnished because.
both the writ petitions are taken up together at the motion stage for disposal by this common order. The Office of the Chief Engineer Roads PWRD Assam had issued an invitation, had issued a press notice inviting tender dated 6/8/2025 for submission of bids, inviting bids for 79 numbers of packages for construction of roads under Mukhyamantri Pakipot Nirman Asoni bracket MMPPNA bracket close under RIDF 31 Roman 31 of NABARD for the year 2025-26 in Borpeta, Kachar, Soraido, Hubli, Hailakandi, Kamrup, Dhemaji, Morigao, and Sribhumi districts of Assam, amounting to rupees 263.66 crores approximately, including GST, etc., from approved and eligible contractors registered with PWRD Assam. Full stop. Subsequent thereto, by issuance of a corrigendum dated 26/8/2025, the packages were reduced from 79 to 78, and the total amount was reduced from 263.66 crores to 256.62 crores. Further to that, it was mentioned that the details may be seen from 28/8/2025 instead of 18/8/2025. The detail in the present in WPC number 5491/2025, the petitioner herein is interest is a in herein who is a class 1 contractor is interested in submission of his bid. It is pertinent to observe the materials on record further show that a detailed notice inviting tender was issued on 26/8/2025, enlisting the 78 packages. The petitioner in WPC number 5491/2025 is interested in package number 58. The details of which are reproduced here in under page 25 what I say report query.
Actually, it is serial number. Serial number 58, package number is, it is in column 4, page 25.
Okay, he is interested in a package at serial number 50.
58.
The details of which is reproduced here in under. The petitioner in WPC number 5494/2025 is interested in submission of the bid in respect to the packages at serial number 59 and 60. The said packages being relevant are reproduced here in under page 26 of this. This court further takes note of that in the detailed notice inviting tender, the time schedule has been duly mentioned. The last date, the date for submission of the bid is fixed on 5/9/2025. And the last date for submission of the bid is on 19/9/2025 up to 1400 hours. The technical bids would be opened on 19/9/2025 at 1430 hours. The issue involved herein pertains to the requirement of a certificate, requirement of submission of a mandatory site visit certificate with the verification from the concerned engineer authenticating the visit of the bidder to the site of the work and submit the same along with the bid. Taking into account the relevance, clause 7 or 7.1. Clause 7, which details out the site visit condition, as well as clause 7.1 is reproduced here in under. The case of the petitioner in WPC number 5491/2025 is that he visited the site on when?
4925, para 6.
On para?
6.
On 4/9/2025
Then repeatedly 3 days, para 7.
and submitted an application to the executive engineer, that is the respondent number 3, for authenticating the site visit certificate on the same date. However, the said certificate was not issued for which a legal notice was also issued by the petitioner, by the counsel of the petitioner on 10/9/2025, but to no avail. এইখন petition ক'ত? আৰু এখন আছে নে? আৰু এখন আছে? In WPC number 5494/2025, the petitioner have categorically stated at paragraph number 6 that he visited the sites in respect to packages at serial number 59 and 60 on 4/9/2025 and submitted an application to the respondent number 3 for issuance of the site visit certificate, which however having not been issued, the petitioner had, through his legal counsel, have issued legal notices to the respondent number 3. However, to no avail. When the matter was taken up, Mr. B. Gogoi, appearing on behalf of Mr. B. Gogoi, the learned additional advocate general, had submitted an instruction to the effect that the respondent number 3 had received the letter dated 5/9, had received the communications on 5/9/2025. But the petitioners had not communicated with the office for site visit certificate. And as such, the certificate cannot be provided mere on the basis of a letter submitted. It was also mentioned that the certificate can only be provided after physical verification, including the contractor himself / herself, along with PWD officials, validated by geotech photographs. The said instructions were produced is kept on record and marked with the letter X. Have you taken geotech photographs or not?
We'll take it, Malagi.
Have you
It is-
taken or not?
No, we have not taken it because there's nowhere it is written that geotech is. required.
Mr. B.D. Das, the learned senior counsel, appearing on behalf of the petitioner, submits that a perusal of the instructions to the bidders nowhere would show that there is a requirement of production of a geotech photographs along with the PWD officials.
Including that format, madam, page 35.
He also submitted that the format also does not mention so. It also paragraph 9, 10, 11. Nine and 10 to DD board of the. This court have duly heard the learned counsels appearing on behalf of the parties and have duly perused 9, 10 na lagi. clause 7.1 of the instruction to the bidders as quoted herein above. It is the opinion of this court that in terms with clause 7.1, the bidder has to acknowledge that he had duly examined this work, site of work and its surroundings and have obtained all information that may be necessary for preparing of the bid and entering into the contract for construction of the works. Under such circumstances, this court does not find that there should be no, does not find any inhibitions on the part of the respondent number 3 to countersign the site visit certificates. This court also cannot be unmindful of the fact that the materials on record only mentioned that the petitioners have visited, but there are no geotech photographs taken by the petitioner. And if merely submitting an application and in the opinion of this court, therefore, merely by submitting an application without showing evidence that the bidder had duly visited the site by producing a photograph with geotech location, it would meet the very clause 7.1 of the instruction to the bidders authorize. Mr. B.T. Das, the learned senior counsel appearing on behalf of the petitioner, submits that the petitioners are not adverse to submitting photographic evidence about their visit to the sites in question and submitting before the respondent number 3 in both the writ petitions. Mr. B. Gogoi, the learned additional advocate general, submits that upon submission of the photographic evidence with geotech location in the location, the respondent number 3 would countersign the site verification certificate without insisting on the presence of the PWD officials in the photographs containing the geotech locations. Considering the above, this court disposes of both the writ petitions with the following observations and directions. Number 1, the petitioner are given the liberty to visit the sites for which they intend to submit their bids and thereupon submit photographic evidence with geotech locations to the respondent number 3. Mr. B.D. Das, the learned senior counsel, submits that the same shall be done tomorrow. That is so and so. This number 2. This court directs the respondent number 3 in both the writ petitions that upon submission of the photographic evidence the respondent number 3 shall issue the, shall sign the site verification, shall countersign the site verification certificate. So, which have already been submitted by the petitioners on 4/9/2025 before the respondent number 3. Full stop. Next. Okay. And there are 13 or 14 to before parting with this court, however, makes it clear that this court had not decided anything as regards the eligibility of the petitioners in respect to the NIT dated so and so 26/8/2025. With the above the incident.
I have said that, my lord, that office, presence of the official while visiting the site is not required.
No, you have not said.
Before the final direction, Lordship has reported that. Is it a Lordship will say, my lord, there is nothing to show in that particular clause 7.1 that it will have to be accompanied by an official.
What is it?
It will be more.
Huh?
No, before that, before the final direction, before the final direction, my submission was.
Without insisting on A2, whose idea? With geotech locations. Now, I say that you have no problem in giving if it is submitted with geotech locations.
As my lord, there is nothing in the clause that it will have to be accompanied by. Because
No,
it is
no,
not.
I-
there, so we
That your
cannot
lordship will
insist.
mention that.
Huh?
That your lordship will mention.
I've already mentioned.
Yes, clause 7 doesn't require that.
7.1.
Deeply well.
Because the PWD official, where will you find it?
Yes, again, there will be.
You cannot have that because you see, if you try to have this PWD official means if somebody may have a convenience also,
Yes.
then that person may not go. And you know how will you take somebody? Huh?
Deeply.
You'll get the order to dates. Mr. B. Gogoi shall duly intimate a copy of this order be furnished to Mr. B. Gogoi, who shall duly intimate the respondent number 3 about the present directions. Yes, what is this?
May it please your lordship. My lord, the jurisdictional authorities had issued the tender notice at page 19, where we are concerned with the fishery at serial number 1 at page 20. On 22nd of September is the last date for submission of tender. Fishery, 60% fishery
22nd of September.
is the last date for submission of
Oh,
tenders.
coming.
Coming. At page 20, if my lord takes up,
Yes.
serial number 1 is
Hey, to me, my will Takmati Develop. Page
See?
20.
my lordships.
Yes.
Serial number 1 is the fishery we are concerned with.
Yes.
It's
Dibru
Dibru
Brahmaputra
Brahmaputra fishery.
Dibru has not left you.
Rahul,
Huh? Where is it? Oh, okay. Yes, Dibru has not left you.
He says so.
Yes, what do you have to say?
So far as the minimum fixed annual revenue is concerned, it's indicated in rupees that
Minimum?
15 annual revenue,
Ah,
15 lakhs, 26,400.
ah.
We say this is irrational, exorbitantly high. Now, what is the basis why we say so?
You said this is high.
Absolutely high.
Okay.
Why? My lord, the fishery was created by a notification of 8 December 17, which lordship finds at page 24.
Yes.
This is the creation of the fishery.
Hmm.
Around 70. And at page 29, following all things, it was given on daily basis settlement. Page 30, the last part, if I may read.
Page?
30, it starts at page 29.
Yes.
the last part at page 30, if I may read, that will be relevant part. May I read?
Yes.
Under the circumstances, the DC Dibrugarh is hereby directed to reassess the revenue of the newly created fishery within 30 days by a committee headed by ADC Revenue with concerned revenues, circle officer, district fishery development officer, divisional forest officer, so and so members in the light of provision of Rule 48 of the Assam Fishery Rules 53 and submit to government for approval so that the process of regular settlement through tender system can be completed within 60 days from the approval of reassessed revenue by government. Further, government is pleased to allow MS Dibrugarh Part 2 and 3 Pisciculture Cooperative Society Limited to run the fishery on daily basis.
Mr. Bonik, this was at troubled times.
No, I'm not on that.
This was at the troubled times where litigations were galore out here, taking into account either you file or Mr. Digonto Das files or everybody files in this,
So far as this is concerned,
isn't it?
Yes.
Because of that, the matter I passed an order. What has happened thereafter? Appeal?
but so far as this is concerned, it was annual revenue of 1,58,171 at that point of time. Now we've given a chart. If Lordship takes up a chart at page 10,
Let us see.
no, calculate a
No,
10%
no.
enhanced value.
Let us see one thing. Whether somebody puts tender on.
True. But for a moment, since it has to follow Rule 48, I absolutely get it, whether someone quotes or not. At page 10, we have given a chart. At 10% enhanced revenue per year is 10.
Yes.
We have computed that, Miller. Assuming 2019, it was 1,58,171. Every year we enhance by 10%. Not compound, simple. 10% it goes higher. Then at 25, it ought to have been 2,80,206. Here is 15 lakhs odd. It's a huge difference coming up so far as Rule 48 is concerned.
What is
Rule 48. When the fishery is created, how the revenue is fixed, the computation is given in Rule 48.
Yes, the deputy commissioner, with the approval of the deputy commissioner. What is this?
This is the deputy commissioner or the subdivisional officer with the approval of the deputy commissioner shall fix the value of each fishery at the time of registration. The minimum lease value of the fixed will be fixed at 15% of the gross revenue of the fishery, which will be calculated as per the following formula.
L is equals to? what is
Lease
it?
value,
Lease
Y is
value
yield.
in rupees, Y is yield rate in kgs into price of the fish as on 1st of the month and area is equals to so and so into 15. Why this 15 business? Or 15%? Will be fixed as 15 of the gross revenue, 15% divided by 100. Oh no, it will be, okay, see, Y into E into A into the percentage. 15 by 100 is percentage.
Because what I am on, Miller, since it was created in 2017, so that was by proclamation under the revenue rules. The deputy commissioner would, at that point of time, this would have been done. Divided by the number of days plus minus a daily basis was settlement was given. I would not have a case, Miller, if this is in around 15 lakhs odd.
What is the price of fish in 2019 and today?
Absolutely. So it could not have been to the marginal difference of 2,80,000 to 15 lakhs odd. So therein we say it's irrational. I leave it to your lordship.
No. The thing is 1,58,171 was per year.
Absolutely correct, my lord. This ought to have been the value when the fishery was created. If created, we go 10% higher per year and reach at 25. So the creation value could not have been so high at that point of time that we reach the minimum annual revenue at 15 lakhs odd. It's up for the government to justify, my lord. It's for if the government says that at the time of creation, it was such that 10% enhance would come to 15 lakhs odd, then possibly we have no case. But we say it's irrational, it's arbitrary, it's too high. arrange. That's all. But 22nd is the date. They can see.
My concern is that, Lordship, it's a daily basis.
Huh?
It's a daily basis. We have ordered on 12th of April 2024 to all this is to withdraw all the deputy, all the daily basis settlement, Lordship. This is an order. This is being upheld by the division bench also, Lordship. So let me clarify from the department whether in this petition they are still running as far as they are.
No. We are not even there in the fishery. No, we have said before then.
I am going to synopsis allowing the private vessel to continue operate the fishery on daily basis. Yeah, in a synopsis you have written, na?
I mean, no, it is
Private responding is running, then.
possibly no.
Let it be tomorrow, this cannot be, I mean, if this is running, if
Huh?
private responding is running,
I do not think so whether running or not.
Who is running?
he is saying that as per his contention, Lordship, private responding is running on daily basis, which cannot be, Lordship, because this order is being upheld by the division bench also, Lordship. So we have to verify from the department, Lordship. So that.
No, no, regardless of the private respondent operating or not, my respect for someone, Lordship is so correct that 22nd, if bids are falling at 15 lakhs odd, then my heart burning would not be so of concern, legal concern. At the same time, my lord, if the fixation of the revenue of the fishery at the time of creation, as per the land revenue,
No, there is nothing to do with the creation. We go as per the formula at 48.
formula is as per creation.
No.
Yes, if I may read once again, my lord.
Yes, read
The
it.
deputy commissioner or the subdivisional officer, with the approval of the deputy commissioner, shall fix the value of each fishery at the time of registration. Registration is section 16. Section 16 comes with a proclamation
Ah.
by the sanction of the state government.
Ah.
Then the fishery is created.
Ah.
So this is the value taken at the time of registration.
And then?
Subsequent 7 years it goes, or someone defaults, whatever happens, then it has to go by a stepwise increase.
Hmm.
What we say, whatever you did in 19, what we get now in 25 is arbitrary and irrational. That value is too high. It's not only that I cannot participate. Of course, I may not be so strong to participate, but certainly state has an obligation to of Rule 48. If I may invite my lord's attention to one more document, my lord. That's at page 27. This is of 18 January 2018, a notification issued by the Additional Chief Secretary, Government of Assam Fishery Department, wherein
This notification, you have not made it. 18 January 2018.
yes,
As per the order passed by the,
Supreme Court.
yeah,
Supreme Court.
Yes,
that order,
yes, Lordship.
have you made it a part of your tender or not?
Yes, we have ordered, Lordship, deputy
No,
commissioner.
no. Have you made it a part of it or not? Quickly follow the directions of the Supreme Court in terms with the order dated 10/7/2025.
Yes.
10/7/2020. Where is your tender condition?
No, it was not.
Tender notice, it is hereby made the
No.
schemes of the fishery insurance. So where is the long list?
No,
Huh?
The fourth sub paragraph,
Yes. This is, how are you doing this?
Here,
It doesn't seem to be in consonance with your office order dated 10/7/2025 or even the order passed by the Supreme Court.
this is being done by actually, NIT used to be published by the DC Lordship, Deputy Commissioner, so we directed them, Lordship.
Ayukta Kajalaya, this is in A1, page 21.
20 is from Mary.
21, if I may read, my lord.
It is
The
Deputy
vernacular.
Commissioner, additional Deputy Commissioner.
Understood, this is being done. So now the question is, but here, why you are putting at 15 lakhs, it is 9 lakhs, 45,000, 58,000?
No, page 21.
Page 22. Oh, this.
Page 21. May I read the vernacular version, you know? ইয়াৰ দ্বাৰা সংশ্লিষ্ট সকলোকে জনোৱা হয় যে
60 শতাংশ. 15,26,800. But are you complying with this order, office order dated 10/7/2025 or not? That's the question. Find it out, we'll take it up tomorrow. There's no urgency.
No, there's no urgency. Only thing is that if the fixation of rate to the honorable court subjective satisfaction is okay.
I am satisfied. Only thing is, have you complied with 10/7 or not?
So even 10/1/18 will.
That is the Supreme Court judgment.
Yes.
If you have not complied, it doesn't seem that it has been complied with.
That's right.
Find it out.
Only, yes, here, lordship, one is there, public is on your constitution or is.
No, kindly see what is the order passed by the Supreme Court. And whereas the Supreme Court in its judgment specifically referred and relied upon the government circular published in the Assam Gazette and which laid down the procedure and requirement documents for tender based
Yes.
here. Whereas based on the said, the Honorable Supreme Court has categorically directed henceforth all tenders
Yes.
inviting authorities must incorporate a specific
yes.
clause in the notice inviting stating that the documents and procedures laid down in the aforesaid government circular dated demand shall be mandatorily followed so long as the said circular remains in it. A copy of the said circular is also to be enclosed with every NIT. Where is the enclosure?
No.
It reads in Assamese, if I may read that first paragraph only.
There is a order.
ইয়াৰ দ্বাৰা সংশ্লিষ্ট সকলোকে জনোৱা হয় যে ডিব্ৰুগড় জিলাৰ অন্তৰ্গত নিম্ন তফসিল বৰ্ণিত মীনমহলখন বন্দবস্তিৰ বাবে অহা ইংৰাজী 22/9/2025 তাৰিখে নিবিদা গ্ৰহণৰ দিন ধাৰ্য কৰা হৈছে। উক্ত দিনা দিনৰ I'll take it to be 2 PM 2 বজালৈকে নিবিদা গ্ৰহণ কৰা হ'ব আৰু বিয়লি 3 বজাত উপস্থিত নিবিদা দাখিল কৰাৰ সন্মুখত কাৰীৰ সন্মুখত নিবিদা বাকচ খোলা হ'ব। ইচ্ছুক স্বীকৃতিপ্ৰাপ্ত সমবায় সমিতি আত্মসহায়ক গোট NGO আদিয়ে নিবিদাত অংশগ্ৰহণ কৰিব পাৰিব। নিবিদাত অংশগ্ৰহণকাৰী সমিতিসমূহৰ সকলো সদস্য 100% মাছমৰীয়া অনুসূচিত জাতিৰ সম্প্ৰদায়ৰ হোৱাটো বাঞ্ছনীয়। সবিশেষ জানিবৰ বাবে অসম চৰকাৰৰ অধিসূচনা নম্বৰ 18/1/2018 আৰু নিম্ন স্বাক্ষৰকাৰী কাৰ্যালয়ৰ পৰা নিবিদা প্ৰপত্ৰৰ লগত দিয়া চৰ্তাৱলী অনুসৰি নিবিদা দাখিল কৰিব পাৰিব।
Lordship, it seems that, and my official lordship, it seems that it is not been incorporated.
Not incorporated.
Huh?
Not incorporated, Supreme Court, condition in line lordship, lordship can.
It is not there.
Not
Not
in-
here, not.
So this has to go. But anyways, you take our instructions. There's no urgency.
Not-
We'll have it tomorrow.
Yeah.
Why? What do you have? He's the fishery. Only thing is as to whether this office order dated 10/7/2025 of
Yes,
your government has
yes.
been followed or not.
Yes, I will follow.
Okay? Because nowadays I keep this bunch for fishery bits. Okay.
I told him we are on a very small campus. Otherwise, we are not against anyone.
But
No, then
very
if that
interesting
is
part,
so,
if
that
the
is-
private respondent is running.
No, no, no.
No, no, it's okay, I'm not on that, but if you have not complied with. If you have not complied with, then I'll direct you to comply with the office order dated 10/7, which is in Supreme Court judgment. And giving him also an opportunity to submit a representation in respect to lessening of.
We have
the-
already done that.
Okay, they may consider,
We consider.
that is a different thing,
Right.
without saying anything that they are entitled. You may consider that is your lookout. But if this is so, if you have not done in terms with 10/7/2025, then obviously. So list this matter, not more day after, list the matter on Monday, Thursday. For motion, on which day Mr. P. Sharma, the learned counsel, appearing on behalf of the fishery department. As well as Mr. S.R. Gurua, the learned counsel who appears on behalf of the district administration. Shall apprise this court as to whether the impugned notice inviting tender is in consonance with the order dated 21/5/2025 passed in special leave to appeal, bracket civil number 18318 of 2024. passed by the Honorable, passed by the Supreme Court. As well as the office order dated 10/7/2025 issued by the Secretary to the Government of Assam Fishery Department. Rustom. List accordingly.
For orders item 7.
Yes, contempt due to paucity of time, the order could not be passed. What is this?
It is a contempt petition for non-compliance of order dated the annexure 1 lordship, page number 11.
Yes, who is appearing? Notice complied.
As notice already given.
Till date, no ID card has been received. You take service upon them. Who is this person concerned? Secretary PhD.
PhD.
Oh, yeah, PhD. Yes, we ask you to obtain instructions in this matter, This court requests Mr. R. Gogoi, the learned standing counsel of the PhD, to obtain instructions as to whether the order dated 28/5/2024 passed in WPC number 335/2021 have been duly complied with or not. So list this matter again on 26th of September 2025. First of, a copy of the contempt petition be served upon Mr. R. Gogoi, the learned standing counsel of the PhD department, so that he is in a position to take instructions. First of, this court further directs the registry to show the name of Mr. R. Gogoi as the standing counsel of the PhD department.
I've given the copy, lordship.
Very thankful. Oh, yeah. Yes, anybody waiting?
Much.
No, okay, nobody wants to meet us.